Second is, my lords, the constitution of a single judge commission of inquiry.
P.N.
Under the
Desai.
Commission of Inquiry
Justice
Act,
P.N. Desai.
for the purposes of looking into this matter. But may I now request lordships to kindly see the terms of reference and the nature of the order while constituting these two orders. They have produced it along with the writ petition. My lords may kindly see volume 2 of the writ petition at page 591.
592.
591 is that first Venkatachalapati report.
Yes.
At 592, my lords, when they say 1/7/2020 for other ಮೇಲ್ಗಡೆ paragraph.
All right.
May I just read that paragraph? ವಿಶ್ವವಾಣಿ ಪತ್ರಿಕೆ ವರದಿಯಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ನಿವೇಶನ ಹಂಚಿಕೆಯಲ್ಲಿ ನಿಯಮ ಬಾಹಿರವಾಗಿ ನಿವೇಶನ ಹಂಚುವ ಮೂಲಕ ಹಗರಣ ನಡೆದಿರುವುದು, ಇದರಿಂದ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಅಪಾರ ನಷ್ಟ ಉಂಟಾಗಿರುವುದು, ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಗಳಿಂದ ಹಾಗೂ ಸಾರ್ವಜನಿಕರಿಂದ ಹಾಗೂ ಜನಪ್ರತಿನಿಧಿಗಳಿಂದ ಬರುತ್ತಿರುವ ಅನೇಕ ದೂರುಗಳಿಂದ ನಿಯಮ ಬಾಹಿರ ಕ್ರಮ ವಹಿಸಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬರುತ್ತಿದೆ. ಇದರ ಸತ್ಯ ಅಸತ್ಯವನ್ನು ಅರಿಯಲು ಒಂದು ತನಿಖಾ ತಂಡವನ್ನು ನೇಮಿಸುವುದು ಸೂಕ್ತವೆಂದು ತೀರ್ಮಾನಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಕೇಳ್ಕೊಂಡು now lordships may kindly see the terms of reference to the under the Commission of Inquiry Act at page 594. Almost, lords, there are about 7-8 questions they have framed. Almost every question refers to illegality of allotment of sites, illegality of the method and manner in which MUDA acted in giving these sites, including as to whether persons had benefited themselves, though they were not entitled to so. But may I request lordships to kindly see terms of reference 6, 7, and 8. ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಪರಿಹಾರದ ರೂಪದಲ್ಲಿ ನಿವೇಶನ ಜಮೀನನ್ನು ನೀಡಿದ್ದಲ್ಲಿ ಅದನ್ನು ಗುರುತಿಸಿ ಸೂಕ್ತವಾದ ಕ್ರಮವನ್ನು ಜರುಗಿಸಲು ಸಲಹೆಯನ್ನು ನೀಡುವುದು. 7. ಕಾನೂನಿನಲ್ಲಿ ಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಗಳಿಂದ ಮೂಡಾ ಸಂಸ್ಥೆಯು ವಶಪಡಿಸಿಕೊಂಡ ಜಮೀನುಗಳ ಸಂಬಂಧಿಸಿದಂತೆ ಪರಿಹಾರದ ಬದಲಾಗಿ ನಿವೇಶನಗಳನ್ನು ಮಂಜೂರು ಮಾಡಲು ಮೂಡಾ ಸಂಸ್ಥೆಯ ವಿವಿಧ ನಿರ್ಣಯಗಳನ್ನು ಕಾನೂನುಬದ್ಧವಾಗಿದೆಯೋ ಮತ್ತು ಬಂಧನಕಾರವಾಗಿದೆಯೋ, ಪ್ರಾಧಿಕಾರದ ವತಿಯಿಂದ ಸದರಿ ಅವಧಿಯಲ್ಲಿ ಹಂಚಿಕೆ ಮಾಡುವ ಸಿಎ ನಿವೇಶನಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಡೆದಿರುವ ಅಕ್ರಮಗಳ ಬಗ್ಗೆ ವಿಚಾರಣೆಗೊಳಿಸುತ್ತದೆ. And in the previous order, they themselves say, ಮೇಲ್ನೋಟಕ್ಕೆ ಸಾಬೀತಾಗಿದೆ ಅಂತ. Prima facie, there is illegality insofar as the entire, let's say, I would not say scam, but entire allegations which have been made. And these are the present complaint on which the governor acted upon, or what was before him, lords, was the same one. But the governor therefore records, if the government is satisfied that the allegations require an investigation, albeit by a retired judge under the Commission of Inquiry Act and by a committee of IAS officers, the principal, lord, then he takes it slightly higher. He says, when a person is accused or there is an allegation against him, the investigations shall not be at his instance or by his choice. This is one of the reasoning words the Honorable Governor takes. Therefore, he uses the word non-partisan investigation is required into the matter, and these Commission of Inquiry do not inspire confidence. This is how, lords, my respectful submission to lordships would be that when these considerations are taken into account, apart from the elaborate notings which they have submitted before your lordships, it cannot be said that there is non-application of it. It is one thing to say the governor should not have acted in this manner or not, but it cannot be said that there is non-application of the mind. But he has applied his mind. He has perused these orders and seen that there is requirement of an investigation even according to the Lord, then about the difference between what's approval and sanction. Sri Rupa, the learned Solicitor General has read their paragraph in that written note itself, lot
Yes,
I've
yes.
given at page 5, para 34, 35, 36, 37.
Yes.
But there is one decision of the Delhi High Court on this
17A.
17A. That in that compilation itself, Lordships. AP Patak versus CBI. That is at page 167 onwards. But there para 9, 10, 11. They were, but this is, I'm sorry, this is about 6A of the Delhi Special Police Establishment Act. That question of consent, same, similar situation. That consent, before investigation. Para 9, Lordships Mechanics.
Yes.
In Mayavati, Honorable Supreme Court was dealing with the case of consent from the state government for the registration of FIR and to investigate the matter. In the absence of which the CBI had no jurisdiction to register the FIR.
No, there is consent.
Five,
under the
well, but
Delhi
it is
Special
not
Police.
these, no, they have interchangeably used the word. Kindly see para 10. There is an obvious distinction between approval, consent, and sanction. Therefore, they club approval and consent as one category and sanction of the other. An approval or consent implies mere concurrence or agreement, whereas sanction confers an authority on the person in whose favor power to grant sanctions conferred. The difference between approval, consent, and sanction is that of a degree in state of Maharashtra versus Janardhan Ramachandran Navalkar. Their lordships have examined that, and kindly permit me to read that paragraph, where they refer to Prevention of Food Adulteration Act, similar provision for consent. Besides, it must be remembered that under Section 20 of the Prevention of Food Adulteration Act only, consent of the commissioner is necessary and not sanction. There is obvious difference between consent and sanction. Consent implies mere concurrence or agreement, whereas sanction confers authority on the person in whose favor sanction is granted. Therefore, considerations applicable in the case of sanction would, in my opinion, not be applicable to case where mere consent is required. Therefore, this is what in Sri Rupa's case, what the coordinate bench says, it is much narrower. The approval has to be very brief. And as the Solicitor General rightly put it across, particularly when it is being exercised by possibly the highest constitutional authority. He does not want to prejudge the entire issue so that it would influence the investigating authority, whatever it is. That is the difference I wanted to bring to Lordship's notice between 19 and 17A. As regards as to whether 17A could be at the instance of the police officer concerned alone, Lordship's decision in Ashoka versus State of Karnataka, in fact, takes that into consideration. Para 534 Lordships are aware of that, where Lordships, in fact, considered this aspect and held that if a private citizen wants to move the court, he has to obtain pre-approval, necessarily implying that he can also move 17A before the competent authority. Then Subramaniam Swami's case relies upon that. Just two or three aspects I wanted to bring to Lordships. One of the arguments which was advanced before your Lordships is that the order of the governor must be tested on a witness principles, etc. Just like any other administrative order. And therefore, if it is found that he did not address himself to the questions which really arose, it must be struck down. That was the line of the argument. But I was wondering whether when a governor passes an order, but notwithstanding the fact that he's answerable, in a way not answerable to the court, but if an order of his is impugned before your Lordship, what should be the approach of judicial review? But one sentence in Bommai's case, though my lord, their lordships were examining decision under Article 356, maybe my lord, throw some light. May I request lordships to kindly see Bommai, my lord, they have cited at, I'll just bring the lordships. They have cited Bommai at lords at page 310. But I am very conscious when I read this, that this was a case where 356.
Article 356.
But Lord, kindly look at the way Lord, their lordships describe the role of the governor when he exercises his power under the constitution. Article 163. Madam, page 639.
We go to para 282.
But I am referring to para 373 first. Lordships get para 373.
Yes.
In 373, if my lords are to see the sentence commencing from, this is not true of our constitution, it says.
Yes.
Lordships get, this is not true of our, para 370. Same copy. But 373 commences from the sentence whenever proclamation.
Yes.
They, they're somewhere in the middle, lordships get that government of Malaysia, they have referred to 58(2).
Yes.
Then the sentence commencing from that is not true of our constitution.
Yes.
That is not true of our constitution. Hence, the president acts on the aid and advice of the Union Council of Ministers and not in his personal capacity. Moreover, there is a check of approval by Parliament which contains members from that state against the government legislative assembly, of which state action is taken as well. So far as the approach adopted by this court in barium chemicals is concerned, that is not classical administrative order, how to test. That's how they'd argue. But kindly, it is a decision concerning subjective satisfaction of an authority created by a statute. The principles evolved then cannot ipso facto be extended to the exercise of a constitutional power under Article 356. The next sentence is what I would request lordships to kindly consider. Having regard to the fact that this is a high constitutional power exercised by the highest constitutional functionary of the nation. Obviously, they were referring to the president. It may not be appropriate to adopt the tests applicable in the case of action taken by statutory or administrative authorities, nor at any rate in their entirety. We would rather adopt the formulation evolved by this court in state of Rajasthan, as we shall presently elaborate. Therefore, lords, having regard to the fact that the order comes from the governor, who, under the scheme of the constitution, is the highest constitutional authority. The principles of judicial review sometimes may have to vary, is my submission before your lordships, insofar that is concerned. But since I am referring to Bommai, I would also request lordships to kindly see paragraph
320.
Paragraph 3. Paragraph 282. In that, they use, these are all very, real exposition of the constitution by the lordships. And they use this sentence, I must state when remarks are made about the governor, kindly look at the sentence where the lordships say.
Yes, sir.
In fact, it would be a case of his reporting against his own government, but this may be a case of wearing two hats. Not when he recommends for wearing two hats. One as the head of the state government and the other as a holder of an independent constitutional office whose duty is to preserve, protect, and defend the constitution. But it is one thing to say the governor is bound to do whatever we say. It another thing to also see that he also holds an independent constitutional office whose preeminent duty is to protect and defend the constitution.
Yes.
But in Bommai again, because they have relied upon the aid and advice of the Council of Ministers.
That is at 320.
Yeah, 320. But in fact, Article 163 subclause 3, what says as to what was the aid and advice given by the Council of Ministers to the governor will not be called into question in any court. Rather, the court will not inquire into it.
That's
no,
slight,
no,
slight dilution later.
That was, when it was cited, what their lordships held is, what happens between the president and the council of ministers, we are not concerned. Ultimately, what is the decision the president makes is what we will look into it for the purposes of arriving at a decision. That is what I wanted to submit, these last four of them. I will address the last question lordships asked about the role of the chief minister. I'll have to answer that. Before that, two other things I must bring to lordships notice. Is one other decision, lords, of course, not for any other purpose. The Terrorist and Disruptive Act, TADA, also contains some sort of a filter like this, wherein words prior concurrence of the authority is required before initiation of investigation. So interpreting those provisions, not in Satyan, one of the lordships may kindly see in that compilation at serial number 7, State of AP versus A. Satyanarayana. That commences at page 181. But I am citing this judgment for this proposition, and I'll bring to lordship's notice as to why this becomes relevant. At page 181, let's get it, paragraph 8. But there is section 20 capital A of the TADA, which provides for a prior permission. But they go to the extent of saying prior approval. Their lordships go to the extent of saying in para A, even an oral approval is sufficient. But the emphasis which I am saying is not in, I was bringing to lordships notice, this is not the first of its kind where prior approval is recommended. Number of central enactments and some state enactments as well as have this prior approval before investigation is done. Interpreting most of these provisions, their lordships hold, that is, it is not something very formal. It is not something which is elaborate. It is something which has to be more informal, considering the prima facie satisfaction of the authority concerned. In Satyanarayana's case, they go to the extent of saying even a oral permission is also sufficient. But this is one aspect. Then I wanted to bring to lordship's notice about this B.S. Yediyurappa's case they have cited. That is division bench judgment of this court. To say about advice, but I must bring to lordship's notice that that decision, division bench decision, in fact, does not state any law, does not make any declaration of any law. And certainly cannot be considered as a precedent.
Does not declare any law.
It does not. But I'll bring to lordship's notice why. That is, lordships have the division bench judgment. Yeah, please. Yes. But there, one of the I had some knowledge of how the matter went.
You had appeared.
No, I had not appeared. I was there as additional advocate general that time. I had not appeared. In fact, if I recollect, Mr. Ram Jethmalani had come to argue this case initially, but I think by the time the matter came up for final hearing, he was not there. But there, apart from other things, the Council of Ministers had sent an advice to the governor. But it so happened during the course of the hearing, the governor, forget referring to that advice was also not available in the file. Therefore, their lordship said that advice which the Council of Ministers have supposed to have been given, it is nowhere reflected. Forget considering that. Therefore, we say that that should have been considered. Is all that division bench says. No argument was advanced in the line which has been advanced today before your lordships about either citing Antule or, for that matter, MP State Establishment Act to say that it was. And the governor there, of course, had granted prosecution. Of course, by the time the matter was heard, the petitioner had ceased to be the chief minister, etc. That is therefore that Yediyurappa's case cannot be cited as a precedent is my submission before your lordships. Then they have relied upon the standard operating procedure, which they say that
The CBI.
SOP, it is for CBI, and according to me, there is no statutory force to that. There is no statutory force because under the Act, there is no power given to the central government to make any guidelines under 17A. There is no provision. So there cannot be by way of an executive instructions add or subtract or dilute the provisions of 17. Then Lords, the last one Lordship said about recommendation, they have said, what is my recommendation? What is my decision has been answered. But may I request Lordships to kindly see 17A once again. Of course, my lords, it is very tempting for us to, my lord, bring records before your lordship to say what has been the decision, etc. But these are all matters, my lords, which may require investigation. But on a plain reading of 17A, lordships may kindly discern how it comes. It starts by saying no police officer shall conduct any inquiry or investigation.
No,
I'll just be
their submission is that
relatable.
have been committed by a public servant under this act, where the alleged offence is relatable to any recommendation made or
But
decision
May,
taken
may
by
I
such
request
public
lordships, may
servant
I request
in
lordships?
discharge of his official
But
functions or duties.
lordships may kindly see, there is the first sentence, lordships may kindly permit me to.
Yes, yes.
No police officer shall conduct any inquiry or investigation into any offense. Lordships may kindly see. Lordships may permit me to emphasize, into any offense alleged to have been committed by a public servant
Under this act.
That is a comma. There is a comma there.
Comma.
There is a comma.
Under this act,
That's true.
any offence
Any offense for that.
under the Prevention of Corruption Act.
That's true.
Yes.
But I will just demonstrate before your
Any
lordship.
offence, it can be any offence under the act.
Yes, comma, then it is followed by where the alleged offense is relatable to
Yes,
any recommendation made or decision taken by such public servant
yes.
in the discharge of his official functions or duties without the previous approval. Now, my lords, the Prevention of Corruption Act starts from 7 to section 7 onwards, refers to several of the offenses.
Yes.
All the offenses there, my lord, do not per se involve a decision or a recommendation of the public servant. For instance, lordships may
No,
kindly
section 7 is straight away, it is a criminal misconduct by a public servant where he is trapped or accepting money or others.
no, lordships may kindly see
13 is disproportionate.
no, lordships may kindly see section 7C, for instance.
Yes.
If for instance, 7C, lordships may kindly see. Any public servant who
Induces
perform-
another.
No, I am only trying to make this point for you. Let me explain what is that I am trying to say.
So you're trying to bring in the
All offences-
acts that are now foundation for the sanction under 7C.
No, I'm not referring to the present facts of the case. It could possible also, it is possible 7C is also invoked. Maybe. I am at this stage, it may not. All that I am bringing to lordship's notice is if a reading, a correct reading of 17A is made, it encompasses all offenses under the act. Lordships may permit me to state in the same
Yes,
breath.
all offences under.
Need not, therefore they use the word relatable to the recommendation or the decision. For instance, 7C, for instance, what 7C makes it an offense if a public servant induces another public servant to do an act for the benefit of himself or any other person.
Yes.
There obviously there is no recommend or decision by him. Lordships may keep this proposition in mind. But would that not take away the filter of 17A? No, obvious answer according to me is no, because it speaks of any offense under that. Therefore, not the word relatable to any decision or a recommendation must be meant to mean any relatable to the offenses, right from 17 to 30. It need not be, put it across simply, it need not be that there must be a decision taken by me or a recommendation made by me, which is culpable of for any of the offenses commencing from 7 to 30.
Yes.
It could be more in a given situation. It may be perfectly open for anybody to argue that recommendation may include oral recommendation as well. But I'm only bringing to lordship ultimately, the Honorable Supreme Court has held this is the Prevention of Corruption Act. The interpretation must be to ensure the laudable objects of the act is fulfilled and not to allow delinquent public servants to get away by such interpretation. My submission before your lordships is that. Therefore, whenever we speak of a recommendation or a decision to be made by the public servant concerned, it need not be, I'm not saying but in this case, I'm for a moment not suggesting that. It need not be a recommendation or a decision per se, but if any of the offences under 7 to 13 are invoked, it would be certainly the protection of 17A will come. Of course, the alternative argument of Mr. Tushar Mehta that if according to them 17A is not applicable, then it also leads to investigation any other way is something which Lordships will kindly consider. Therefore, Lords, my respectful submission to Lordships is that having regard to these aspects, the writ petition at this stage would not call for any interference. That, my lord, the petitioner, I must bring to Lordship's notice, is at a stage where there is a threshold beginning. He would get many more opportunities in case, my lord, anything adverse is taken by either the magistrate before whom the private complaint may go or before the station house officer if a first information is to be lodged. He would get an opportunity in case an adverse, let us say, my lord, a first information report is.
So the complaint is already before the sessions court.
It is complaint is before the sessions court, but no orders are passed. But all that I'm saying is
that was awaiting approval.
No, all that I'm saying is it is not that they will not have an opportunity. In case an adverse or if something is to be done there, they will certainly have an opportunity to call into question. Therefore, Lords, my respectful submission is that this matter does not call for interference. Of course, Lords, I must say, I do not want to use the word profound respect, which Mr. Tushar Mehta gave a different meaning, but having regard to the totality of the circumstances, but I did not want to repeat myself as to what Mr. Bennett Solicitor General had dealt with.
Yes.
I'm sorry, Lord, if there has been some repetition.
He's behind the television. I could not see him. Yes. He's TV ಹಿಂದ್ಗಡೆ ಇದ್ರೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಈ ಕಡೆ ಬಂದು. ನೀವು ರಿಪೀಟ್ ಮಾಡಲ್ಲ ಅಲ್ವಾ?
Respondent number 3, my lord.
ಗೊತ್ತು, ಅದು ರಿಪೀಟ್ ಮಾಡಿ, ತೊಂದರೆ ಇಲ್ಲ.
No, my lord. There's no repetition of any of the grounds, my lord,
Yes.
which were urged earlier.
R4. 5 ತಾನೇ?
At the outset, my lord, Lord, I was, my lord, in the previous state of hearing, I was assailed primarily on the ground that I had earlier applied for sanction, and now, my lord, in my statement of objections, I have taken the stand that I don't require sanction. Lord, I was assailed on that ground that my approach is uncertain. Now, my lord, Lord, what was the cause of action for me to approach the Honorable Governor seeking sanction? Now, if my lords may kindly take to page 261, my lord, which is nothing but the operative portion of my lord's judgment in Dr. Ashok's case.
Page 261 of what?
Lord, of the writ petition.
ಅದರಲ್ಲಿ ಹಾಕಿದಾರ?
Please. Page 261.
Yes.
Lord, the second paragraph, Lord, which my lord had rendered, a private complaint should also append prior approval granted by the competent authority to register a private company. I would stop at that, my lord. Lord, the word append, my lord, which is nothing but a synonym of the word attach or add.
Correct.
Lord, now that being the case, my lord, Lord, I would be, my lord, disabled to even, my lord, go before the special judge and place my complaint, my lord, at the hands of the special judge.
Correct.
Because
You had to take approval.
I had to take approval.
Yes.
So that is why, my lord, I had approached the Honorable Governor.
Who is saying that is wrong?
Lord, now it is now that, my lord, I have also, my lord, in my statement of objections, I have contended that I don't need sanction and I have quoted reasons for this.
That's your contention. It's all.
Please, my lord. My lord, the reasons being.
So
my
to
lord,
bring it in tune with Ashok's case, you
please,
you
it was
approached
only,
the governor.
It was only an adherence and respectful compliance. My lord, in fact, when I, my lord, approached the Honorable Governor, the same question, my lord, was posted to me.
Now,
Because,
one clarification.
please.
Before approaching the governor, you had approached the jurisdictional police by registering complaint.
Please.
ಅದು ಮಾಡಿದ್ರಾ?
Both 154(1) and 154(3).
Both are complied.
Both are complied. Both are complete.
And
Thereafter,
ಆಮೇಲೆ 200 was invoked.
no, thereafter governor's sanction was sought for.
Sought for.
Sought.
ಆಮೇಲೆ you filed the
Then, my
complaint.
lord, I have filed a private complaint. Pending approval from the honorable government. My lord, since, my lord, there was a dictum, my lord, which was laid down by my lords in Dr. Ashok's case, I had to, my lord, without choice, approach the honorable government. Since I was disabled, my lord, to even approach the special court. My lord. There was a circular, my lord. A circular, my lord, would signify that it's against the general public as well. So I was bound to comply. My lord, since, my lord, Dr. Ashok's case, my lord, it was not the case at hand when my lordships dealt with Dr. Ashok's case. My lord, Dr. Ashok's case, my lord, with due respect, my lord, to my lord's dictum. My lord, in Dr. Ashok's case, my lord, a situation where a private complaint, my lord, is placed before a special judge, and, my lord, if at all, the very case or the very allegations do not warrant sanction under section 17A, then, my lord, how the special judge must treat the situation?
It
my
was
lord?
not why Ashok was written.
No, it is not, my lord. That is my contention.
In
It is
Ashok's
silent in that
Ashok's
regard.
case, what happened
Please.
is, prior to Ashok, there were 13, 14 cases.
Please, my lord.
Against public servants, they approached the competent authority seeking approval under 17A.
Absolutely.
It is kept pending or not granted.
Not.
Though there are several
Please.
allegations of which would touch upon cognizable offense or corruption or whatever. Then straight away they used to approach the magistrate. Once the magistrate or the special court refers the matter for investigation, there is no choice but to register an FIR.
Please.
That is why here they don't get the registration of FIR because 17A bar is
Please.
there. They get an FIR straight away there. That is why Ashok was written, that approval there also would be required
Required.
from competent
Please.
authority. Otherwise, the very section would be rendered nugatory. That is the reason that was written. Yes, and that is why you have also applied for
No, my lord.
approval.
My contention is that, my lord, in fact, my lord, looking to the facts of the case, my lord, the allegations specific, not, my lord, warrant seeking sanction for section 17.
Approval. Approval is 17, 218 is sanction.
Because 17A, my lord, the expression, my lord, in discharge of official duty or in connection to official
Even 197 also the same thing. 218 is 197, yes.
Now, that very expression, my lord, in connection to the official duty or integrally connected to the official duty. My lord, in the instant case, if I take my lords to the gist of the allegations made in the sanction application. Just to attain full clarity, but although facts
No,
are partly-
extensively, yes.
On 20th/8/1997, there was a final notification.
92 preliminary notification, 97 final notification. Yes, 1997.
And I'm also not on legality of acquisition and.
That's what. It's all right, yes.
Now, pursuant to this notification, but the ownership of the land, my lord, ownership and possession of the land stood vested with MUDA.
MUDA.
The revenue records from the year 1998 to 2004, my lord, would clearly denote this. Subsequently, my lord, on 30th March 2004, final award notice, my lord, came to be issued. Final award notice.
2004.
30th March 2004,
All
final
right.
award notice came to be issued. Lord, by 15/6/2004, there are, my lord, numerous sites that were formed and also allotted to the respective allotments, which is, my lord, forthcoming from the allotment register put up at
Sites were also allotted.
page 135 and kindly.
Yes.
Kindly page 135 and kindly. This is the allotment.
Yes. 135 of the writ petition.
Type copy of the allotment.
Yes. ಇವರಿಗೆಲ್ಲ ಅಲಾಟ್ ಮಾಡಿರೋದ ಇದು?
After complete full-fledged layout was
ಮಂಜೂರು ಮಾಡಿ ಕ್ರಯಪತ್ರಗಳನ್ನು ಈಗಾಗಲೇ ನೀಡಲಾಗಿದೆ. ಕ್ರಯಪತ್ರಗಳನ್ನು ನೀಡಲಾಗಿದೆ.
conveyances were
Yes.
But now, my lord, I would travel I would again travel to 1998. Now, this denotification, my lord, was in the name of one Ninga, my lord, Ninga son of Javra. My lord, he was by then, my lord, no more, my lord.
Denotification yavaga?
My lord, 18/5/1998, my lord. 18/5/1998.
Yes. Hmm.
Lord, this denotification, interestingly, was 45 days after the issuance of final award notice. This may kindly be noted down. 45 days, exactly 45 days after the issuance of final award notice.
All right.
Now, my lord, it is for the legal heirs of the deceased person, my lord, in whose name the denotification was done, for them to reclaim the physical possession of the land, my lord. Lord, in fact, till date, my lord, till date, there has been no claim over the possession of the land. Till date, it remains the same. From, my lord, the date of denotification. The possession still vests with MUDA. Now, my lord, now coming back to 15/6/2004, my lord.
Hmm.
Lord, there was any more, my lord, the Devanuru third stage, the Kesre Grama, my lord, which is the land in question, survey number 464, Kesre village. Lord, it ceased to exist, my lord, by the year 2004, as per the records. It ceased to exist because
of-
Devanuru Padavane came into the place.
Because.
Because
sites
Devanuru
were-
Padavane came into place, which comprised of full-fledged layout, inclusive of roads, parks, sites, and other civic communities.
All right.
Now, my lord, as produced from the allotment register, my lord, by, my lord, 15/6/2004, there were numerous allottees, my lord, who were allotted these sites.
All right.
My lord, on 25/8/2004, my lord, 25/8/2004, a sale deed, my lord, came to be executed by one Devraju who claims to be the owner of the land.
Of what land?
The same land in question, my lord. Now, here, my lord, although the Devanuru Badavane no more exists,
Huh.
he states that he is the owner of the said land in question, and he executes it. And he executes a sale deed.
That
Although, my lord, Kesare Grama ceased to exist and only Devanuru Badavane is in place. On 25/8/2000.
sale deed refers to Kesare Grama.
Lord?
Sale deed refers to Kesare
Sale
Grama.
deed refers to Kesare Grama. Sale deed refers to Kesare Grama, which
Yes.
is not in existence anymore. Man. Now, my lord, in the sale deed, if my lordship may kindly peruse, at page 122, my lord, of the red petition.
Hmm.
I'm sorry, my lord. First, my lordship may kindly peruse page 118, my lord. In the third paragraph, my lord, unnumbered third paragraph. If I may read, my lord.
ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ನಮೂದು
ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ನಮೂದು ಮಾಡಿರುವ ಸ್ವತ್ತು ನಮಗೆ ಪಿತ್ರಾರ್ಜಿತವಾಗಿ ಬಂದಿದ್ದು, ನಮ್ಮಗಳ ಪೈಕಿ ಒಂದನೇ ಜಿ ದೇವರಾಜ ಆದ ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ಖಾತೆ ಹೊಂದಿದ್ದು, ತಹಲ್ವರವರೆಗಿನ ಕಂದಾಯವನ್ನು ಕಟ್ಟಿಕೊಂಡು, ಕೈಂಡ್ಲಿ ಮೈ ಲಾರ್ಡ್, ದಟ್ ಮೇ ಬಿ ಟೇಕನ್ ನೋಟ್ ಆಫ್ ಮೈ ಲಾರ್ಡ್, ಕಂದಾಯವನ್ನು ಕಟ್ಟಿಕೊಂಡು ಆಲಿ ನಮ್ಮ ಸಂಪೂರ್ಣ ಮಾಲೀಕತ್ವ ಮತ್ತು ಹಕ್ಕು ಬಾಧ್ಯತೆಗೆ ಸೇರಿ ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿ ಇರುವ ಸ್ವತ್ತಾಗಿರುತ್ತದೆ. Now I invite my lordship's kind attention to the schedule, my lord, which is forthcoming at page 122.
Yes.
Here, my lord, another interesting aspect, my lord, which would emerge. If I may read, my lord, the schedule, Mysuru ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಕೆಸರೆ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ಸರ್ವೆ ನಂಬರ್ 464ರಲ್ಲಿರುವ 3 ಎಕರೆ 16 ಗುಂಟೆ ಕುಷ್ಕಿ ಜಮೀನಿಗೆ ಸೇರಿದ ಚೆಕ್ಕು ಬಂದಿ. He makes 3 claims, my lord. He makes 3 claims. One is he is alienating an agricultural land. Second is he has paid tax up till 25/8/2004, which is the date of conveyance, my lord.
But by then sites were formed and allotted also.
That is our case, my lord. There were,
How will it remain agricultural land?
my lord, that is what, my lord, a non-existent land was subjected to a conveyance. It has been. And the third assertion, my lord, that he makes is that he had retained ownership and possession till 25/8/2004.
All right.
Lord, a non-existent land, my lord, was sold. Non-existent land was purchased. Possession, my lord, of the non-existent land was handed over.
Now, who purchases it?
Purchased one by Mallikarjunaya, who is none other than the brother-in-law of the petitioner.
All right.
Please. Now, my lord, The next development, my lord, 15/7/2005. 15/7/2005.
15/7.
15/7/2005. Uh, I may invite my lordship's kind attention to page number 136, my lord.
Yes.
Lord, this is an order of conversion, my lord.
Version.
Conversion order. Land, my lord, was fully developed. The Kesre Grama ceased to exist anymore. Now, the same land, my lord,
After this B.M. Mallikarjuna Swami
after
purchased it.
Mallikarjuna Swami applies for conversion. He applies for conversion.
Yes.
By order dated 15/7/2005, my lord, an application for conversion of a non-existing agricultural land was, my lord, filed by Mallikarjuna Swami. And by order dated 15/7/2005, my lord, the then DC, my lord, one Selva Kumar,
All right, it is, conversion is granted.
conversion is granted, interestingly, based on two field inspection reports, my lord.
Based on inspection reports.
Based on spot inspection report, please, my lord. By both by the Tahsildar and DC, my lord. Now, my lords may kindly peruse page 138, my lord. 138. My lord, this is the spot inspection report of the Tahsildar.
Hmm.
If I may read the topmost portion, my lord. ದಿನಾಂಕ 4/3/2005 ಕಸಬಾ ಹೋಬಳಿ ಕೆಸರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 464 3 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನಿನ ವಸತಿ ಉದ್ದೇಶಕ್ಕಾಗಿ ಶ್ರೀ BM ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಎಂಬುವವರು ಭೂ ಪರಿವರ್ತನಾ ಮಂಜೂರಾತಿ ಕೋರಿರುವ ಜಮೀನನ್ನು ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಕಸಬಾ ಹಾಗೂ ಗ್ರಾಮ ಲೆಕ್ಕಿಗರೊಡನೆ ಸರ್ವೇಯರ್ ಜೊತೆಗೆ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿರುತ್ತದೆ. Subsequently, my lord, another report, my lord, where the DC gives a report stating that he has visited this spot, which is forthcoming at page 139, my lord. Please.
DC also.
DC also, my lord. In fact, if I may quote, my lord, the DC one, Shri Kumar Nayak, is, my lord, presently the MP of Raichur district. Just for intimation, my lord, nothing more than that. He also, my lord, he says that he has visited this
What
spot.
has that got to do? Yes.
Thank you.
All right.
Now, my lord, I would once again, my lord, draw my lordship's kind attention to page 136. Once again, my lord. Please. Illi, the third paragraph, my lord, unnumbered third paragraph.
ಅರ್ಜಿದಾರರಿಗೆ ಅದ
No, no. Mysuru ನಗರಾಭಿವೃದ್ಧಿ.
ನಗರ ಪ್ರಾಧಿಕಾರ.
Please. ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನಾಧಿಕಾರಿಗಳ ಪತ್ರ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 3/9/98 ಪ್ರಸ್ತಾಪಿತ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರವು ಭೂ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳಲು ಈವರೆಗೂ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿರುವುದಿಲ್ಲ. Lord, the notifications are before my lords. Now, the sanction is granted based on the ground that the land was never subjected to conversion. And, my lord, which lands, my lord?
The very same 3.16 acres.
Very simple. Kindly, it may be perused, my lord. The survey number, the village name, everything is identical, my lord.
All right. Next.
My lord, which lands, my lord, did the revenue officials visit, my lord? Probably my learned senior friend was referring to Wonderland, my lord. Alice in the Wonderland. But here, there is Mallikarjuna Swami, my lord. No Alice. But Wonderland exists. No, my lord. A conversion, my lord.
Land is converted.
Land is converted. Non-existing land is converted.
All right.
Lord, now, my lord, my lordship pointed out before my learned senior started, what is the role of the chief minister? Lord, see, petitioner, my lord, wants this court to believe that these, my lord, blatant illegalities were committed by the offences on their own volition or their own will and fancy. Is it, my lord, possible? Now, I would, my lord, take my lords to further developments. Subsequently, my lord, now we would travel to 2010, my lord, from 2005 conversion.
Then page 140 is
My lord, this is a gift deed. Gift deed.
gift deed from
Gift deed. From Mallikarjuna Swami to his sister, who is none other than the wife of the petitioner.
this very land, 3.16 acres.
3.16 acres. My lord,
But where is the land?
There is no land. That is our case, my lord. Non-existent land has been subjected to multiple conveyances. Non-existent land has been subjected to conversion. That too upon spot inspection of the Tahsildar
No,
and the.
You only told me that 97 final notification,
Please,
33 final award notice.
please.
Then 15/6/2004 land is formed, sites are formed and allotted to everybody.
Please.
After that, all these things have happened.
After that, all these things have happened.
All right.
My lord, how could the revenue authorities, my lord, find and identify an agricultural land, my lord, to pass an order of conversion? But these are the shocking facts, my lord, which emerge, my lord. Once we go further, my lord, there are even more.
Inno-
There-
okay.
there-
Yes.
Please, now I would take my lords to the gift deed. My lord.
Hmm.
Gift deed, my lord, was made by my lord one Mallikarjuna Swami, who is none other than the brother of the
I
brother-in-law of the
Gift deed is in accordance with law.
No, my lord. How can it be, my lord? Non-existent land is gifted.
Well, he has purchased some land, got
Yes.
it converted.
Got it.
He has gifted it.
My lord, where was the land to purchase?
That is, we'll see. But
It has to
these
be.
things are in accordance with law. It's all right.
My lord, registration is in accordance with law.
All
But,
right.
my lord,
Yes.
he claims
Sale deed registration is accordance with law.
only no, my lord, the registration process is in accordance with law, but the gift deed, my lord, my lord, it is inherently, my lord, invalid because there's no land, my lord. There's no land at all left. Post 2001, my lord, there is no, I mean, the Kesaragramma ceases to exist.
ಈಗ
Yes.
sites form ಆಗಿದೆ.
Sites are formed. Numerous number of allottees were allotted sites. How could, my lord, they claim that an agricultural land exists?
All
And
right.
in the gift deed as well, why I would say, my lord, this gift deed is fraudulent is that in the gift deed, my lord, he says that he's been paying tax till 2010. To which land, my lord, was he paying taxes? Was it inclusive of the sites, my lord, that are allotted?
Sites are not allotted to him anyway.
My lord,
Yes.
it is allotted to somebody else. my
Yes,
lord.
somebody else.
How could?
No, land is denotified. Denotified, 1 minute.
My lord, they have come up with an explanation.
18/5/1998 denotified. Then how did MUDA form sites and distribute it after denotification? It should vest to the owner.
My lord, they have given explanation, my lord. In the cabinet note, they have
Huh?
given an explanation.
Compensated whom? The landowners.
That is exactly, my lord.
Well, who is compensated now? Title holder of the day, not the landowners who lost their land then. No, sir, after denotification, it should go back to the landowner, go back to the government. Go back to MUDA rather. Yes. It's gone back to the owner. Owner is that Devraj, is it? Who sold the land to Mallikarjun? Owner is Devraj. The title holder as on the date of the preliminary
He is
notification.
not the owner, my lord.
Then?
No, that is one of the, without going into, that is one of the allegation. Allegation, I'm not,
No, all right. Yes. Then MUDA formed sites in the agricultural land.
allegation is not the
Lord.
twofold allegation. Not-
No, sorry.
No, no,
So it was mistake of MUDA in forming sites in an agricultural land. So that is why compensation is granted. Well, who will question?
How would they question, my
Who
lord?
will question?
How would they question?
Well, it's a personal thing. Why will someone question the gift deed? No, gift deed is purely personal between who's the donor or the donee. That we'll see, yes.
My lord, now, my lord, in connection to the ownership, kindly, my lord, pages 78 may kindly be perused of the writ petition. Page 78, my lord.
Anyway, 1992 owners are Allah.
No,
Owners were different.
Not at all. Page 78 may kindly be perused.
Allegation,
my lord.
just one interjection. The allegation is like this. The original owner died. He had 3 sons. Among them, my lords, there was an arrangement by which one person, one Mailaraya was held the property. But the land is sold by some other person to these persons.
That Devraj or someone.
Devraj,
Who
he
the
is,
son, my lord? Lord,
No, no,
in fact, who the
Mailaraya,
son?
Mailaraya's name continued. No, these are all allegations. Mailaraya's name continued in the record
Alright.
of rights.
Let him finish.
No, I'm just only supplementing what my learned friend is saying.
Yes.
But page 78 may kindly be perused, my lord. Because exactly what I'm trying to put forth, my lord. There are numerous transactions, my lord, in the encumbrance certificate,
Hmm.
which are forthcoming. Only Mailaraya's name, my lord, would reflect
Throughout,
throughout.
up to 2003.
Please.
All right. Yes. Anyway, these are on facts.
These are on facts. My lord.
Yes. Muks
I mean, that's not our concern, my lord. We are never getting into
Very good.
ownership.
That's
please.
what, these are on facts. Yes.
Please, please. My lord, coming back to the gift deed, my lord. Now, in the gift deed, my lord, there were some, my lord, affirmations which are made, that is in connection to possession and tax being paid. How could, my lord, one be in possession of an already developed land by a development authority?
No, it was denotified Andralla.
But physical possession, my lord, remained with the MUDA, and it is still unquestioned. And they, my lord, in the cabinet note, they admit that the compensation is being paid because in the year 2001 itself, MUDA had encroached and they had developed the land
Right.
unintentionally. I mean, that is their affirm, my lord. What they say is that the intimation of denotification was not given to the concerned officer of the MUDA. Therefore, my lord, they were under the impression that the land is still under acquisition and they had, my lord, proceeded. That is their explanation, my lord. It is not my version. Lord, through this gift deed, my lord, in fact, my lord, nothing was sold, my lord, from the beginning, and nothing was purchased, and now nothing is gifted, my lord. Now, based on this nothing, there is something which happens, my lord. On 23/6/2014, my lord. On
23/6,
23/6/2014,
page.
my lord, at page 143, my lord. 143.
Hmm.
Lord, this is during the, my lord, in fact, I had to make reference to the cadre, my lord, occupied by the petitioner at the relevant junctures.
Kedaralla, post.
Please. In 1998, my lord,
Ah.
I mean, during the denotification process which happened, he was, it was in the tenure of the petitioner as a deputy chief minister.
1998.
1998.
Ah.
1998.
All right.
Please. And even during the conversion process, my lord, during the spot inspection, order of conversion,
Hmm.
even at this juncture, he was the deputy chief minister of the state. Now, my lord, once again, my lord, reverting back to 23/6/2014, my lord, this was during petitioner's tenure as the chief minister. Please. My lord, an application, my lord, for compensation, my lord, is filed by the petitioner's wife, my lord, which is, my lord, forthcoming at page 143, my lord. Now, the interesting
Compensation after the gift.
after the gift, after 4 years after the lapse of gift, 4 years,
All right.
4 years after the gift, after the lapse of 4 years.
Compensation for what?
Please, my lord, now I would invite my lordship's kind attention to page 143.
No compensation for MUDA.
Compensation for the very same land, my lord, that is allegedly claimed to have been encroached by the MUDA.
No, the original landowners were not compensated.
No, my lord. No.
All right.
No, my lord. Coming to the last line, my lord, I would not go through the entire record, my lord. ಉದ್ಯಾನವನ್ನು ಅಂತ ಬಂದಿದೆ ನೋಡಿ ಮಾಸ್. ಅಭಿವೃದ್ಧಿ ಪಡಿಸಿ, ಪ್ಲೀಸ್ at page 143, ಉದ್ಯಾನವನ್ನು ಅಭಿವೃದ್ಧಿಪಡಿಸಿ 2001ರಲ್ಲಿ ಸದರಿ ಬಡಾವಣೆಯಲ್ಲಿ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. This is her claim. My lord, where was Mallikarjunaya in the year 2001? How could conversion, my lord, said to have been done? When in the year 2001, it is her claim, my lord, it is not my claim. It is her letter. It is her affirmation. All right. Now, my lord, in connection to this application, my lord.
So either ಈ role ಅಲ್ಲೆಲ್ಲ at the time when either the petitioner was
He was
deputy
the
chief
chief-
minister or chief
was the chief-
minister, it has happened.
It has happened.
So you attribute this to that.
No, I will come to it.
Yes.
There are few more, my lord, specific allegations. Now on 25/7/2014, my lord, on 25/7/2014, I may take my lords to page 144, my lord, of the writ petition.
Hmm.
My lord, 1 month from the date of application, my lord, the earlier application which I referred to,
For compensation,
please, a
Ah.
compensation by the petitioner's wife.
all right.
Now, my lord, there is a proposal, my lord, before the MUDA, that, my lord, the UDD department, my lord, comes to a decision where farmers, my lord, to be compensated at a 50-50 ratio, my lord. Earlier it was 40-60.
All right.
Now, my lord, within, my lord, a short notice, within short time after the filing of application by the petitioner's wife,
Hmm.
this decision has been taken, my lord.
Hmm.
Now, my lord, I'm not, my lord,
All right.
I'm not completely, my lord,
Hmm.
assailing the petitioner in this regard, but, my lord, although it appears public interest, my lord, now the private interest of the petitioner's wife also is taken care of.
All right.
Subsequently, my lord, on 18/8/2014, my lord, now, my lord, MUDA, in response to the application filed by the petitioner's wife, my lord, at forthcoming at page 149, my lord.
Seeking, that is 18/8/2014.
Please, 18/8/2014, please,
Commission, it's
please, my lord,
compensation.
please, my lord.
ಅನುಪಾತದಲ್ಲಿ ಅಭಿವೃದ್ಧಿಪಡಿಸಿದ
Please.
ನಿವೇಶನ ಯಜಮಾನ ಬಡಾವಣೆ.
Now, MUDA, my lord, will derive at a market value, or, my lord, it was decided that to give alternative developed sites in a similar layout, my lord, in a 40-60 ratio. My lord, upon which land, my lord, this was computed is the question, my lord, which is still unanswered.
Now this is paid or sites are granted?
Sites are granted. Now, my lord, if my lordship may once again, my lord, refer to page 135, at this juncture, how many sites are granted? It's clearly forthcoming. Near about 20 sites are, my lord, granted thereafter.
Now,
Please, allotted already.
where is the allotment of sites now?
My lord, page 135, my lord.
ಅದು ಹಳೆಯದು allotment.
No, same list, my lord. The list continues till 2009, my lord, in fact.
ಅಲ್ಲ 135 ಅಲ್ಲಿ 19 sites were allotted
Please,
to different people.
to different people
All right.
in the same in the same land in question.
All right.
Please.
Now what is allotted?
No, my lord. At the relevant point of time, there were already. My lord, I'll come there.
All right. Now ಇದೆಲ್ಲ ಆಯ್ತು. Now 60-40 ratio ಅಲ್ಲಿ it was asked. Now land is allotted or not?
Sites are allotted.
Sites are allotted.
Sites are no. Sites are not. I mean, the sites, my lord, in connection to the respective allottees were allotted. Now, what happens with the petitioner's wife, my lord? I will come to it.
Hmm.
I will come to it. My lord, now this compensation, my lord, was it, my lord, for the lands occupied by the MUDA in the year 1997, or, my lord, for the lands, my lord, which were already utilized in the year 2001, or, my lord, for the non-existing lands in the year 2004, which was subjected to gift deed, or, my lord, the lands which were subjected to conversion in the year 2005, or a non-existent land which was gifted, my lord, by the petitioner's brother-in-law to the petitioner's wife. My lord, absolutely, my lord. My lord, who is petitioner's wife, my lord, to claim compensation, my lord, is the question, my lord. It's an intriguing question.
No, after the gift, she comes into the shoes of the owner.
I'm sorry, my lord.
No, after the gift
Please.
from brother,
Please.
she becomes the owner of the property.
My lord, how could she, my lord? How could she, my lord? How could she become owner, my lord, of a non-existent land?
That you tell. That's
Please,
all
that is
right.
what
Yes.
I'm trying to put forth, my lord. Lord, in fact, in 2001, my lord, our brother, my lord, he himself was not even in possession of the, my lord, of the land that he claims, my lord.
So he comes into position in 2004.
No, he never comes into possession, my lord, because possession still vests with MUDA till date.
All right.
It still vests with
All
MUDA.
right. On paper, at least comes into possession.
On paper. Plain paper was created, my lord, in connection to a non-existent land.
Right, we'll see.
Please.
Hmm.
Thereafter, my lord, 11 to 2015, my lord, page 50, my lord, page 150, page 150. 11 to 2015.
150.
Please, 150. Now, as earlier decided by the MUDA in the year 2014, my lord, I have made a relevant mention regarding the same. Now, this 50-50 rule 3 was modified, my lord. So as to enable the MUDA to
Right.
hike the compensation. 50-50.
Yes.
Even during this tenure, the petitioner was the chief minister.
All right.
Please.
Hmm.
Now, my lord, Again, my lord, automatically, my lord, the illegal claim, my lord, made by the petitioner's wife would, my lord, certainly get enhanced.
Hmm.
Now coming to the year 2017, my lord, more specifically 15/12/2017 and 30th/12/2017.
Hmm.
My lord, the MUDA council meetings, my lord, wherein, my lord, it was decided, now based on the application, my lord, which I referred to, application seeking compensation. Based on that application, my lord, it was decided in lieu of the acquired land, my lord, it was decided that a parcel of land measuring 13,759 square meters, my lord, would be given as compensation. My lord, shockingly, even after this, my lord, on 25/10/2021, now we'll again come back to 25/10/2021 when the petition, my lord, was the leader of the opposition. 25/10/2021. My lord, another application came to be filed to the MUDA, page 160.
Hmm. For what? For what?
My lord, similar claim, my lord. It
All
was
right.
reiteration of the earlier letter. Reiteration of the earlier letter.
So now what has happened? Sites are granted or what?
My lord, now thereafter, I mean, it still continues, my lord. There are 2 or 3 junctures, my lord, which I want to put forth.
Me.
Because, my lord, until we dissect, my lord,
Suspense is still going on.
no, until we dissect, this wrongdoing, my lord,
No,
cannot
this
be.
is going on till the cows are coming back. Yes,
Please.
tell me.
Lord, on 25/10/2021, reiteration of the earlier application, Lord. Another application came to be filed on 25/10/2021. Lord, in response to the said application, my lord, MUDA, my lord, dated by order dated 23/11/2021, which may kindly be perused, my lord, at page number 161, my lord.
Hmm.
Please. My lord, in which, my lord, the reference is, my lord, made to the 3 meetings, my lord, on 15/12/2017, 30th/12/2017, and 20th/3/2021. And further reference is made to the 2 applications, my lord.
You are attributing undue influence of the
Absolutely.
office of the chief minister
Office of the Chief Minister.
to
Please.
generate all these
Please.
things. The
Please.
foundation is that.
Please.
All right.
Absolutely.
Asked.
Now, my lord, thereafter, my lord, after post 2021, my lord, in response, my lord, in response, on 25/11/2021, my lord, upon direction of the ASLO, my lord, release deed, my lord, came to be executed.
Release date of what?
Release deed of this property,
3.16 acres.
survey number 464.
All right.
That land, my lord, is the subject
Release
matter.
in favor of?
Release in favor of MUDA. Because the decision was taken that we will compensate you, so therefore you
Release
release
in
your.
favor of MUDA.
Please. My lord, all this, my lord, when there was only Devanuru Badavane, when there was only Devanuru Badavane in existence, and Kesare Grama, my lord, ceased to exist long back. When there was a full-fledged layout, my lord, at this juncture, probably from 20 years, my lord, at the relevant juncture. 20 years back itself, my lord, Kesare Grama has been deleted.
All right.
Therefore, my lord, the releasing the title and ownership of a non-existent land, my lord, which I would say. My lord, on 5/1/2022, now the culmination of all this, my lord, allotment letters, my lord, for 14, my lord, 14 compensatory sites came to be allocated. 14 compensatory sites,
Illig Bunny.
which is forthcoming at page number 178 to 194. Individual allotment letters to various sites. Lord, interestingly, my
Individual
lord,
allotment letters in favor of,
petitioner's wife. Petitioner's wife.
all right. That's 176. Page 176.
178, my lord. 178. 178.
Oh, these are allotment letters. is it?
These are allotment letters.
All right. ಆಮೇಲೆ
Lord, one interesting aspect, my lord, which my lords must observe. In the allotment letter, my lord, in the allotment letter, a reference has been made to meeting that was held on 20th/10/2020.
20th November.
20th/11/2020.
Hmm.
Please. in the fourth line, my lord,
Yes.
please.
Mm.
Now, my lord, the ALSO in his direction, my lord,
Yes,
the
sir.
ASLO in his direction, he never, my lord, when he directs the petitioner's wife to relinquish the rights over the land in question, he never, my lord, makes reference to this meeting, my lord. All of a sudden, my lord, this is now parachuted into the
Parachuted?
allotment letter.
Parachuted.
Out of nowhere it has come, my lord.
Yes.
Out of nowhere.
Ah.
It is parachute.
Mm.
My lord, another, my lord, interesting aspect, my lord. My lord, at page 159, my lord, if my lords may kindly peruse, during the MUDA meeting, my lord, during the MUDA meeting held on 20th/3/2021, I'm sorry, my lord, I had missed on an aspect which I should
No
draw
problem.
my lord's kind attention to.
We're going here and there, it's all right.
In this very meeting, my lord, the petitioner's son, my lord, he was also part of the meeting in his capacity.
Now, where did the son come from?
He appears here, my lord. He
You
appears
were-
here. Please. Kindly, my lord, page 159 may kindly be perused. In page 159, serial number 10.
10 na?
Serial number 10.
Ah,
Hajaridda Sadasyaru. Page 159, my lord.
all right.
Please.
As an MLA sitting there.
He was an MLA then?
He was an MLA, my lord, but the cabinet's reply to the same, my lord, is in fact, I will come to it.
They knew that they were filing a complaint, you would not have been there.
No, in connection to the presence of the petitioner's son, my lord. I will come.
All right. ಈಗ ಅದಾದ್ಮೇಲೆ ಇದು ಮುಗಿಸ್ಬಿಡಿ ಇದು.
Please,
Ah.
please.
Because all this while I was under the impression only the wife of the chief minister was there. You are bringing the son also now.
My lord, he is the part of two meetings held by the MUDA. Held by the MUDA. No,
ಬೇರೆಯವರು
sir,
ಇದ್ದಾರಾ?
I may kindly be permitted to complete.
ಅದ್ರಲ್ಲಿ ಬೇರೆಯವರು ಇದ್ದಾರೆ. ಹಾ.
Others idare. But their reply, my lord, in their reply they state that he is only present and he has not participated in any of the
He
meetings.
is there.
That is their reply. My lord, on two occasions, my lord, he is present, which is when the said application, my lord, was placed before the MUDA, my lord.
All right.
The two occasions are 20th/11/2020, which is, my lord, forthcoming at page 304, page 304,
Hmm.
and 20th/3/2021, which I referred to some time back.
ಇವೆಲ್ಲ ಒಂದು written
I will
submission
I will hand it over. Please, please. Therefore, my lord, to conclude, my lord, in connection to the allegations, my lord, a non-existent land, my lord, was subjected to a sale deed. A non-existent land was subjected to conversion. Thereafter, a non-existent land also came to be gifted, which my lord, I earlier called it Wonderland.
All right.
Then subsequently, my lord, compensation was claimed for losing nothing.
Like 14 sites ಆದ್ಮೇಲೆ ಏನಾಯ್ತು? Relinquish ಮಾಡಿ.
She has received the sites.
Compensation is
She has
granted?
received the sites.
No. The sites are now.
14 sites are the compensation.
Now 14 sites are in possession of the wife of the chief minister.
Till date, as admitted by the petitioner. And that 55 crores, my lord, I mean,
What is the value of those 14 sites?
that is the value of those 14 sites. It's my computation, my lord. Now, the petitioner, my lord, I mean, off the record, my lord, if I may say, the petitioner comes to the news media and he says, it's worth 62 crores.
All
And
right.
he says,
Somewhere there.
And he says, compensate me with rupees 62 crores. I will return these sites. That is what he says on the news media.
All right.
Right.
Ashana,
Lord, now coming to the,
it's still coming.
the gist is over.
Yes.
I am done with the gist.
Yes.
Now, my lord, whether
Hmm.
sanction is warranted in my case.
Approval.
Approval and sanction. Approval
Sanction
and
218, that stage has not yet come.
Please. My lord, I will confine myself to 17 name. I would not, my lord, delve into the technicalities of section 218 of BNSS. My lord, I would say that sanction, my lord, in my case is not applicable on two folds. Firstly, my lord, the offenses, my lord, the most part of the sequential offense is, my lord, committed prior, my lord, to the insertion of section 17A into the prevention of corruption. That being the case, my lord, now as per the dictum, my lord, laid down in Tejmal Chaudhary's
All
case,
right.
which I would, my lord, refer to. Madam. Yes. Illegal. Tejmal Chaudhary. Lord, at page 204 of the compilation, my lord.
ಅವ್ರು ಕೊಟ್ಟಿದ್ದೀರಾ ಕಾಪಿ?
It's given, my lord. I served this soft copy.
204.
204. No, sir, I haven't, I don't, I do not have it. No, I mean, I have received the hard copies today, sir. Lord, I would, my lord, first go through with the keynotes, please. Page 204. 2022 live law SC 158. SC 198. 158. 158. If I may.
ಹೆಸರು ರಂಗನಾಥ್ ಅಲ್ಲ?
Please.
ಸಿ ಪ್ಯಾರಾ 6. ಅಷ್ಟು ಓದ್ಬಿಟ್ಟು ಮುಂದೆ ಬರಿಬೇಕಾ ನೋಡಿ.
Lord,
ಅಷ್ಟು ಓದ್ಬಿಟ್ಟು ಮುಂದೆ ಬರಿಬೇಕಾ ನೋಡಿ.
please, my lord, I will
Read.
please. In this case,
Read it loud.
the FIR was filed on 1/1/2018. Before
Stop
this,
there. FIR was filed on 1/1/2008
filed.
prior to the provision coming into force. The provision comes into force on 26/7/2018.
Lord, para,
ಅಲ್ಲಿದೆ, ಅದೇ ಡೇಟ್ ಇದೆ ನೋಡಿ. 26/7/2008. If the FIR is filed prior to the act coming into force, it is obvious that it should, the act would not, the 17A would not become applicable. Here FIR is registered. FIR is not yet registered, but the
not yet
complaint.
registered.
Sir, incidents may have taken place 100 years ago, or 50 years ago, 10 years ago, but 17A is in place today. You are registering the crime today. 17A would be applicable. This is a case where FIR had already been registered. You cannot give retrospective effect to 17A and say already registered FIRs also will have to pass muster 17A. ಅಷ್ಟೇ ಅದ್ರಲ್ಲಿ ಇರೋದು.
Not the apex court says offences which existed prior, my lord.
Sir, offenses ಅಂದ್ರೆ ಏನು?
Lord,
What
not
do you mean
mere-
offenses ಅಂದ್ರೆ not in the imaginary kind of offenses. Offenses that are depicted in a crime. That is on 1/1/2018 FIR is registered. That is why Supreme Court wrote 17A would not have retrospective effect for FIRs already registered. New incident, see, something would have happened in
Yes.
2015. 17A is not applicable. You want to bring up that incident of 2015 in 2020 and seek to register a crime against a public servant. You're registering today. Incident may have happened, then it's not post facto law concept iduk baralla.
Lord,
But that is the judgment there. ನೀವು ಅವತ್ತೇ ಕೊಟ್ರಿ ನನಗೆ ಇದನ್ನ.
I've taken
I
this
was also
contention, my lord.
surprised.
It's
ಯಾವ್ದು
for my lords to.
incidents, see, I will write, that's a different
Please,
thing. But
no, my lord, this is not the only ground, my lord, which I'm.
no, I am not saying that. I am not telling you that you are wrong also. I'll have to apply my mind on that. That's a different
Please,
thing.
please.
But this judgment, FIR was already in place. ನೀವು ಅದನ್ನ ನೋಡ್ಬೇಕು first.
Certainly, my lord. I
Facts
mean,
and
I'm not
then law.
disputing the fact, my lord.
Yes.
But since, my lord, offenses, my lord, in crude meaning, my lord, offenses, my lord, the offense existed prior to the insertion.
Sir,
As per the allegation.
offense may have existed. It comes into light
Please.
in a particular
No,
way.
I would, my lord.
See, you may project delay.
Please.
That's a different thing.
Please.
Whoever, the accused may project delay in registering the crime. But 17A applicability, retrospectivity, yes, definitely.
Please. My lord, I would oblige to my lord's view on this. But
That
anyways,
the
the
Supreme
contention
Court has
was
written,
taken.
we will consider.
Please, please.
Yes. This
No, my lord.
judgment went on that footing that FIR was already registered on 1/1/2008.
Please. Lord, whether to the allegations, my lord, forthcoming in the, my lord, instant case, whether 17A would be warranted.
That you tell.
Please.
Yes.
Lord, I invite my lordship's kind attention to page 191, my lord, rendered by the Kerala High Court, wherein reference was made to many other High Court judgments. My lord. Page 191, my lord.
191 of your compilation.
191 of my citation compilation.
191 is it?
191.
191 ಯಾವ್ದೋ ಮಧ್ಯದಲ್ಲಿದೆ ರಂಗನಾಥ್.
TO Suraj versus State.
ಹಾ,
Lord, 148.
148.
148.
What is the ratio here?
Lord, paragraph 13, my lord, page 13, paragraph 13, my lord.
Page 13.
Page 13, paragraph 13,
All right.
please. The expression anta ಶುರುವಾಗುತ್ತೆ ಮಾಸ್.
Yes.
The expression discharge of his official functions or duties in section 17A of the Act reflects the legislative intent that the protection envisaged is not a blanket protection.
All right, 17 ಬೇಕಾಗಿಲ್ಲ ಅಂತ ನೀವು
ಬೇಕಾಗಿಲ್ಲ. This is not, my lord, in connection to the decision taken or recommendation made by the petitioner. My lord, in connection to the same, my lord, your lordship may kindly peruse page 43, my lord, 43 and 44, my lord. I would straight away draw my lordship's kind attention to para 55.
Against
forthcoming
whom are you complaining now?
against the petitioner, his wife, and the officials, my lord.
And you just now said that it is undue influence
And you,
of the chief minister
please,
in the when holding office
please,
that he has done all this,
please.
is what you said.
Absolutely.
So ಅದಕ್ಕೆ 17 ಬೇಕಾಗಲ್ಲ.
Bekagala.
All right. We
Because
can-
it is not in recommendation or, my lord, or in any manner, my lord, it is not in discharge of his official duty.
All right.
My lord, the same, my lord, had been reiterated in other authorities, my lord, which are forthcoming at paragraph 55, my lord.
Hmm.
55, the authority rendered by the Honorable Delhi High Court, and 56, my lord, which is in conformity, my lord,
Hmm.
by the Honorable Chhattisgarh High Court, and 57, my lord, which is on the similar lines, my lord, rendered by the Honorable Madras High Court.
ನೀವು ಒಂದು ನೋಟ್ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ.
I'll file it, please.
All ನಿಮ್ ಜಡ್ಮೆಂಟ್ಸ್ ರಂಗನಾಥ್, ಜಡ್ಮೆಂಟ್ಸ್ ಯಾವ್ದ್ರಲ್ಲಿ ಆಗಿದೆ?
Please, along with the extractions, I will furnish.
like how the others have done.
Please, I will file,
Same manner.
along with the extractions, I will file it.
ಇನ್ನ ಏನಿದೆ?
My lord, in connection to, my lord, whether it is a relevant stage, my lord, to obtain sanction under section 218, my lord. of
Sanction is not the stage at all.
Not at this stage, my lord, although, I mean, it's
ಅಲ್ಲ
been-
ಅಲ್ಲಿ ಹೇಳಿದಾರೆ ಅಷ್ಟೇ. Sanction
ಹೇಳಿದ್ದಾರೆ.
is not in that stage at all. It is post investigation.
that is what, my lord, I
That
wanted
you
to
need
clarify.
not-
my
you
lord.
need not
Because
labor on
Manju
that.
Surana's case, my lord, is
So you need not labor on that. No, Manju Surana's case, whether
section 19.
156(3) ಗೆ ರೆಫರ್ ಮಾಡಬೇಕಾದ್ರೆ sanction ಬೇಕೋ ಬೇಡವೋ ಅಂತ. That is now
Absolutely.
referred to a larger bench.
Please,
That larger bench is being constituted now. That's all right.
Lord, about
That
3
is,
months
that is
back.
what was said in MK Ayyappa.
Please.
That was doubted in Manju Surana and
Manju Surana.
referred to a larger
Lord, in
bench.
fact, my lord, recently, my lord,
ಅದೇ, that is what now the court has directed it to be constituted immediately.
my lord, very recent dictum, my lord, in this
ಗವಾಯಿ
regard.
ಅವ್ರದ್ದು ಇರ್ಬೇಕು.
Madam,
ಆಗೋಗಿದ್ಯಾ ಜಡ್ಮೆಂಟ್?
no, my lord, not Manju Surana. This is also, my lord, referred to Manju Surana, but this is the recent dictum, my lord. What they have expressed, my lord, in this regard.
It was referred to a larger bench on 27/3/2018.
Please, my lord. Now, this is of the year 2024, my lord.
ಅಲ್ಲ ಅದು ಗೊತ್ತು ಹೇಳಿದ್ದು.
Please. No, they have just,
156(3) ಗೆ ಸ್ಯಾಂಕ್ಷನ್ ಬೇಕಾ ಬೇಡವಾ ಅಂತ.
they have formed an opinion, my lord, at page 3, my lord. Although the division bench.
Again, I'll tell you one thing.
Please.
ಈ 156(3) ಗೆ ಸ್ಯಾಂಕ್ಷನ್ ಬೇಕೋ ಬೇಡವೋ ಅಂತ, that was found to be necessary at the stage when 17A was not in the statute.
Please. Absolutely, my lord.
So that is why the matter was referred. Now 17A itself acts as that protective layer of sanction,
Because-
whether required for 156(3) or
Please,
not. This, that's
Because
what,
Ayappa, my lord,
MK was 2012, sir.
was at the teeth of
Yeah.
my lord R.R. Chari. So
Yes,
therefore,
because that's
three
2012.
judgments. Yes, yes, my lord. So, my lord, recently also, my lord, before my lord ordering to
Now,
place,
that is why 17A takes care of 156.3 at the stage of, the stage of, sorry, takes care of sanction at the stage of 156.3.
please. My lord, now, my lord, in this connection, I would just read the relevant portion, but I will conclude with this. My lord, we are of the considered opinion, considered view that scanning of the provisions under section 156 subclass 3, 173 subclass 2, 190, 200, 202, 203 and 204 of the CRPC would prima facie reveal that while directing for an investigation and forwarding the complaint thereof, the magistrate is not actually taking cognizance. However, since the said question is referred as per the above judgment, judicial discipline and propriety dissuade us from proceeding further with the case, and hence we order to tag the caption matters along with Manju Surana. But because this will be the next contention.
No, no.
After, if at all, madam,
All those were rendered in a scenario where 17A was not there.
because before this Giants case was, my lord, rendered by the Honorable Apex Court. So therefore, my lord, these are the recent, my lord, views
Whether
taken by the-
Manjusurana comes about or not, or what is written, 17A is already in statute.
we do not know, my lord.
That's
Because,
it.
because the respondent number 3's petition, my lord, which was challenged before the Honorable Apex Court, TJ Abraham versus Yedurappa. I mean, that, my lord, now it may be tagged along with Manju
Point
Surana.
number 3 and then?
TJ Abraham.
Oh, that's
Yeah.
the.
Please.
Yes, yes.
It was, my lord, the reported dictum of this Honorable Court, which is now under challenge, my lord. Probably these are all these, my lord, the questions would
No,
be answered.
that's what I feel in sense. 17A ಇದೆಯಲ್ಲ ಅದಕ್ಕೆ ಅಂತ ಅಷ್ಟೇ.
Please. So 17A, my lord,
ಅದೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ ಬಿಡಿ.
please. So therefore, my lord, 17A.
Application of mind and other things of the governor you need not labor because the
No, my lord,
Solicitor
I would limit
Solicitor
myself.
General himself has told.
Lord, I would limit myself, my lord. Since non-issuance of show cause notice, my lord, is made out as against the other respondents, certainly I am immune to that ground, my lord, because in my case, show cause notice was
It's
issued.
already issued, so you
Because
need not
notice was
labor on
issued.
others ground.
Please. Lord, the Honorable Governor, my lord, certainly has followed due process in my case, my lord. In fact, after, my lord, having heard me for 1.5 hours, my lord, this question was placed as against me.
Oh.
How could I grant sanction? at
You were
the
there for
relevant
1.5 hours.
stage? 1.5 hours. I was being heard.
Hmm.
But, my lord, the voluminous documents. my lord.
Right, okay.
In fact, my lords took time to understand how all this is transpired. Then imagine the governor, my lord, who is a non-judicial entity.
I took time. All right.
Certainly, my lord. My lord, mere issuance of show cause notice, my lord, on the same day, that has been assailed, my lord. My lord, this Honorable Court issues hundreds of notices, my lord, every day. Now, for mere issuance of show cause notice, my lord, as though it is, my lord, portrayed as a death warrant, which is issued immediately.
ಅಂದ್ರೆ ನಾನು ಇಶ್ಯೂ ಮಾಡಲ್ಲ ಇನ್ಮೇಲೆ. We will take
On a
list
lighter
after 4 weeks for issuance of notice.
On a lighter note, my lord, hundreds of show cause notices, my lord, are issued day in and day out.
In the lighter way, sir. Yes.
Yes. My lord, now, my lord, in connection to MP Special Forces, my lord, now, in fact, on the first day, my lord, when the matter was being heard, my lordship pointed out whether only 120B, my lord, is coming forth as against the Chief Minister. That was the question, my lord, posted to me.
Yes.
Please. My lord, 120B, my lord, is, my lord, an intangible offense. The same, my lord, has been, my lord, observed in MP Special Forces, my lord, which I would
The
refer
actual
to the
commission is
relevant-
not, actual commission is not required.
please. Actual commission is not required, and at page 404, my lord, kindly, of the compilation, my lord, page 404 of the compilation.
Judgment.
Please, my lord.
ಅದಕ್ಕೆ ಜಡ್ಮೆಂಟ್ ಬೇಡ ಸರ್.
No, my lord, I'll just read the relevant portion,
Read.
please. The office of the Lokayukta, this para 29, my lord, of the MP Special Forces case. The office of the Lokayukta was held by a former judge of this court. It is difficult to assume that the said high authority would give a report without any material whatsoever. We, however, do not intend to lay down any law in this behalf. Each case may be judged on its own merits. In this case, however, we are satisfied that the Lokayukta made a report upon taking into consideration the materials which were placed or received by him. When the Council of Ministers take a decision in exercise of its jurisdiction, it must act fairly and reasonably. It must not only act within the four corners of the statute, but also for effectuating the purpose and object for which the statute has been enacted. Respondent number 4, in each appeal are to be prosecuted under the Prevention of Corruption Act, wherefore no order of sanction is required to be obtained. A sanction was asked for and granted only in relation to an offence under section 120B of the Penal Code. It is now tried that it may not be possible in a given case even to prove conspiracy by direct evidence. It was for the court to arrive at the conclusion as regards to the commission of the offence of conspiracy upon the material placed on record of the case during the trial, which would indulge the oral testimonies of the witnesses.
Rangnath,
Such a-
that's settled principle.
Settled, my lord. Now, my lord, because my lord, emphasis, my lord, was laid on where the signature appears, where was the recommendation. This has been, my lord, being quoted, my lord.
That's why first day I asked you the
Please.
question, is 120B?
Please, it is intangible, my lord. That is what I would say. I mean, it cannot be, my lord. One cannot expect direct evidence, my lord, in connection to 120B. My lord, all these junctures, my lord, I would only want to conclude by saying, in all these junctures, my lord, the purpose, my lord, why I took my lordships chronologically or sequentially, my lord, by mentioning the relevant dates, at all these junctures, he had, my lord, occupied a cabinet position, firstly. And, my lord, can it be said that at so many instances, my lord, that it is a coincidence? Can coincidence reoccur at so many junctures, my lord? Is it, my lord, possible?
All right, we'll consider.
No, my lord, only to, my lord, put forth.
Conclude Andre.
No, my lord. I mean, in that regard, my lord, only to, my lord, put forth the bias, my lord, by the cabinet, my lord. Only to one paragraph.
Settles.
My lord, I would refer to only one
Hey, hey.
paragraph. In fact, first volume. No, I will conclude, my lord, please.
Yeah.
Lord, at page 351, my lord. Page 351. Kindly, lordship, kindly. It's page 351 of the second volume, my lord.
Hmm.
Page 351 of the second volume,
ಅಲ್ಲೇ ಇದೀನಿ.
please. Para 5.20, my lord.
I am there only.
Please.
Yes.
Or 5.21, my lord.
ಆಯ್ತು.
Illi,
In the meantime.
in the meantime, the land number 464 of Kesre village has been used for the development of Devanuru third stage scheme, layout of Mysuru Urban Development Authority, and about 26 plots were created and distributed to the public in the said land. It is only at this juncture, my lord, the cabinet refers to the formation of layout. That is when after 2010-2010, 5.20, my lord, paragraph 5.20 refers to 2010-2010.
This is the part of the cabinet note.
Please.
Hmm.
Now, my lord, absolutely, my lord, there is no averment in connection to the claim which says that in the year 2000, back in the year 2001 itself, the layout was formed. Very cleverly, my lord, that has been brushed away from the cabinet note. They only refer to the development of layout post 2010. Lord, this is the, my lord, genuinity of the cabinet note.
ಒಂದು ಪೂರ್ತಿ ನೋಟ್ ಕೊಟ್ಬಿಡಿ.
Please.
Hmm?
It's
ಅಷ್ಟೇ
just that, my lord, they want the fruit of the crime, my lord. Now they would, how could they, my lord, disown illegalities? It has been openly claimed, my lord, that it is my land. Now they only want to disown illegalities. Compensation, my lord, was obtained by losing nothing.
All right.
I would only want to, my lord, conclude with this.
Conclude.
Please.
Yes. Good.
They're all lords, sir.
My lords.
One
What's that?
submission, no, I'm not arguing. Sir, 1 second. I just wanted to say.
Issued by the police
Sir,
in that
ಯಾವುದಕ್ಕೆ?
ಅದೇ retrospective ಇದ್ರ ಬಗ್ಗೆ.
ಯಾವ retrospect?
Morning I made a submission that the sanction is given in respect of a provision which was not in force on the day.
Post facto. Yes.
ಅದಕ್ಕೆ
My lord,
there is a police circular directing the police authorities to register cases, taking note of that fact.
Yes, at once. ಇದು ಇದರಲ್ಲೇ ಆಡಿ ಮಾಡಿ. Petitioners. ಒಂದು ಯಾವ್ದಾದ್ರು folder
I just wanted to add
ಒಂದು loose sheets ಎಲ್ಲ ಒಂದು folder yes.
one caveat I just wanted to add regarding all these factual aspects which are being put forth before.
Governor ಇದನ್ನ ನನಗೊಂದು ಕೊಟ್ರಲ್ಲ.
These are all instances to show the
None
material which was
of
before the governor. They, of course, not.
prima
They
facie.
had, possible, not several inferences could be drawn.
Lord, now, my lord, allusive attempts are, my lord, being made to create some nexus to the instant petition with the proceedings before the special court. That
Which
is to,
special court?
my lord, since complaints are, my lord, now instituted before the special court,
All right.
although, my lord, that is not called in question.
No, but you are the complainants, you are being heard on that
I am the
only.
complainant, my lord,
Yes.
but the interim order, my lord, is also, my lord,
That's all right. See,
please.
I'm
That's
deciding the
frustrating
issue.
the proceedings before the special court.
See, why I granted the interim order? When I am hearing the matter, no subordinate court will
No, no, I mean, I'm no.
continue with the proceeding.
Lord,
That
I'm
is
no
not correct.
dispute-
That's the reason I have stalled everything there.
Lord,
I'm hearing it. I'm hearing
That
it.
is, that is their primary interest, my lord.
That's a
Under the
different-
guise of challenging the
No, it's
sanctions,
all
they have,
right.
my lord, challenged.
Whatever, see, whether sanction is required or not, I have to decide. If I say sanction is required, whether it's correct or not, I have to decide. Then if the court proceeds in the
The special court.
oh no,
It would be subject to the.
what do you mean subject to the decision? Oh no, sir. Subject to the result of the writ petition antivi atarana. Oh no, sir.
And now that lordships have heard the
No,
matter.
that's not, that submission I will not accept, Rangna. That I have stated consciously stalled further proceedings.
We-
Well, finish fast, we'll finish fast. That's all. I am not wanting to hold this for long. Yes.
My lords, Mr. Raghavan will follow next, my lords.
Huh?
Mr. Raghavan, my lords. He has some submissions to make, my lords.
ಇವ್ರು ಮಾಡಿದ್ರಲ್ಲ
After Maninder, my lords, only did half of it, my lords. Mr.
ಮೇಡಮ್
Raghavan has.
ನಿಮ್ದು ನೀವು
Madam, ಒಂದು IA ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಕೊಡಿ ಕೋರ್ಟ್. ಕೊಟ್ಟಿದ್ದೀನಿ.
Pursuant to that, Manoj, I'll take some time after they finish.
ಸಮ್ ಟೈಮ್ ಅಷ್ಟೇ,
But
otherwise
there's an IA, my lord, filed.
it's taken the whole day.
But there's an IA filed, madam.
ಹಾ, ನೀವು ಇಂಟರ್ವ್ಯೂನರ್ ಎಲ್ಲರೂ ಹೇಳಾಗಿದೆ ಬಿಡಿ, ಇನ್ನೇನ್ ಹೇಳ್ತೀರಾ?
No, my lord.
ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಬ್ರೇಕ್ ಡೌನ್,
My lord,
very
bef-
important.
my lord, before that, my lord, I have made an IA, my lord. I
Ah.
filed an IA.
ಫಾರ್ ವಾಟ್?
My lord,
ಒಂದು ನಿಮಿಷ, ಫಾರ್ ವಾಟ್?
Lord, it's under section 195B, read with 314.
ಯಾಕೆ ಪರ್ಜುರಿ ಯಾಕೆ?
Please, there's a false assertion, my lord, which was made regarding
Sir.
pendency of proceedings, sanction proceedings before the honorable governor, my lord. Now, my lord, I have received a.
ಏನ್ ಪೆಂಡೆನ್ಸಿ ಸ್ಯಾಂಕ್ಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್?
It was alleged, my lord, that in connection to 4 legislators,
ಹಾ,
sanction, my lord, the application seeking sanction was pending before the
ಇಲ್ವಾ
honorable
ಅದು?
governor. No, my lord, it is.
ನಿಮಗೆ ಹೆಂಗ್
disposed.
ಗೊತ್ತಾಯ್ತು?
I have obtained through RTI, my lord.
RTI.
Please.
ಸೊ ಯಾವ್ದು ಪೆಂಡಿಂಗ್ ಇಲ್ಲ?
Not even one single, in connection to one single legislator, it is pending.
There is averment in the petition
It's
also.
the averment in the petition. Kindly, the application may be perused.
ಕೊಡಿಯಲ್ಲ, ಇದೆಲ್ಲ.
If I may read the RTI reply, my lord.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
No, Lord, copy is not served, my lord, because they cannot, my lord, audience the court, my lord. This is a perjury process. It's the domain of the honorable court. They are
That
disabled.
way, even the SG need not have supplied the copy. He has supplied it.
Lord, I don't.
What's the problem, sir?
Copy.
ಅಲ್ಲ, that's the ground. Yeah, RTI reply ಏನು ಇಲ್ಲ ಅಂತ ಹೇಳಿದಾರಾ?
Absolutely, my lord. In connection to every legislator, my lord,
It's already disposed.
it's already disposed of. In 2 cases, my lord, sanction is granted. And in 2 of them, my lord, it is been sent back, my lord, for some
Alright.
seeking some clarification.
All. So nothing is on the table,
Single
on the
case-
table of the government.
Not even a single case is pending before the governor.
Yes.
It was a false affirmation that has been made.
Decide.
Same is forthcoming at paragraph number
ಇದೊಂದು
18.
extra, I'm already, if you see everything, sea of issues have to be decided. One more. Yes.
Paragraph number 18, my lord, to be
Not-
specific.
No, the material is there already. File is placed. We'll look
No,
into
madam.
the file and then decide.
File pertaining
No,
to
at
this
the
case has
conclusion
been
of-
produced, man, not file with regard to the, whether those
No,
four. Anyway, my learned friend is now produced, man.
Under the RTI.
Yeah, it's
code,
produced now, yes.
definite. Nothing is there, nothing is there.
Nothing is there.
No, in fact, the learned SG made a submission that nothing is there. I will produce everything.
Lord, my lordship is aware how this was canvassed, my lord, by the learned senior friend, my lord.
Discriminate.
Only against the petitioner that the sanction is being granted. It's
Pick
being
and
pending.
choose. Picked and chosen.
Picked and chosen.
All right, we'll see. Sir, reply.
No,
Rejoinder ಇದೆಯಾ?
no, we'll have to reply, Manoj, then there.
What is the state government?
I would point out, they argued saying that fairly submitted. I want to say what I fairly gave the opinion.
clarify fairness.
Therefore, I need to clarify a few things, my lord.
All right. Madam, you and Raghavan sir are finishing on what day?
Monday or Tuesday, my lord.
Then other proceedings are held up, sir. I'll give you from 3:30 whenever you want. 3:30 because on day-to-day basis we'll do it, but not before 3:30. The other councils have lost their. Hmm. Mhm. Monday, Tuesday, Wednesday, whatever day,
Monday, 3:30, my lord.
Monday 3:30, you will finish it.
Then Tuesday.
Monday at 2:30,
2:30.
but there are only 150 or something.
I want to file return statement in this. 2 minutes I want to say.
ಹೇಳಿ ಈಗಲ್ಲ ರಿಟರ್ನ್ ಹಾಕಿ.
Return I will file once
Huh.
you allow me what I am about to say.
ಹಾ
Sir, I am an officer of your court, an impeccable officer for the past 25 years.
all
I
right.
am neither the petitioner nor the respondent. Everybody have presented that this matter in their own way. In fact.
You also present it in your own way.
Yes, yes, my lord.
Hmm.
The only thing that I want to bring at this stage to the notice of this honorable court is, I want to read out one particular article.
Constitution.
Yes,
Yes, sir.
just one plain reading so that
Hmm.
everything will be settled by plain reading of.
Settlement.
Yes,
23
not
rule only.
settlement. Much food for thought is given in this, my lord. Please allow me to read one particular.
Read,
like-
sir.
Yes,
But today only 5 minutes.
yes, sir.
Ah.
Honored, my lord.
Yes.
My lord, if any question arises whether any matter or not is not a matter as respect which the governor is by or under this constitution required to act in his discretion, the decision of the governor in his discretion shall be final and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion. Now the lawmakers have put discretion, word discretion.
So the decision of the governor cannot be called in question.
No, it is like this, my lord. I want to say Oxford Dictionary. I want to refer to.
For what, sir?
Discretion. Word discretion.
Oh.
Sir, word discretion. Our lawmaker said the freedom or power to decide what should be done in a particular situation. At that time, our founding fathers were impeccable people of highest moral standard.
Hmm.
They felt that after them, that if they could post this trust in the governors to come after them, discretion would be a wise thing for them, so that they would judiciously use this power vested in them. But much water has flown down river Thames, sir. Dynamics of the Indian politics has changed.
Hmm.
So we are all here.
Hmm.
And the people of Karnataka are going through a turbulent, unstable period now. By
ಏನಾಗಿದೆ
last assembly election, people all choose to vote for a stable government. That
ಈಗ
is now
ಏನಾಗಿದೆ
being
ಈಗ?
shake ಆಗ್ಬಿಟ್ಟಿದ್ದಲ್ಲ.
ಶೇಕ್ ಆಗ್ಬಿಟ್ಟಿದ್ಯಾ?
ಹೌದು. ಒಂದ್ ಒಳ್ಳೆ chief minister ಗೆ been put into all the developmental work has been stalled. And so much there is uncertainty in the air.
You are appearing on whose side?
I am
In neutral.
7 crore Kannadigas, my lord.
One, oh.
Yes, the pride of my state. We are passing through a turbulent stage. The outset itself, I said that I am neither for the petitioner nor the respondent.
All right.
The great honor of meeting my very learned friends, and for whom I have profound respect, as the Tushar Mehta ji told me.
All right.
I am honored, sir, that you
All
gave me the time. I will allow me to file a return statement.
ಬೇಕಾದ್ರೆ ನೋಡೋಣ.
Yes,
Ah.
I am obliged, my lord.
All right.
Place the judgment note,
What judgment?
the relevant para, the note.
Yes. Paragraphs ಹಾಕಿದ್ದೀರಾ?
Along with, they've extracted the.
You know it. Again, you don't do it. Paragraphs ಕೊಡಲ್ಲ.
I've given.
Why I have to search for paragraphs again? ಬಿಟ್ಬಿಡಿದ್ರೆ. ಬೇರೆ ಕರ್ಕೊಡಿ ಮೇಡಮ್. All right, sir.
Yes.
ಇದು ಎಲ್ಲಿ ರಾಘವನ್ ಸರ್ ಮಂಡೇ 2:30 itself. ಮೇಡಮ್ ನೀವು ಮುಗಿಸ್ಬಿಡಿ ಏನಾರಿದ್ರೆ ಅವತ್ತು. ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್, ಬೋತ್ ಆಫ್ ಯು ಫಿನಿಶ್ ಇಟ್. ದೆನ್ ಆಮೇಲೆ ಸರ್ ನಿಮ್ದು ಯಾವತ್ತು?
My lord, I'll do it after that, my lord.
After that, please finish off. I will finish off my list by 1:30. You finish off your arguments later.
No, let them finish, my lord, the respondents, I mean, in the sense,
ನೀವು ಕೊನೆಗೆ ಹೇಳ್ತೀರಾ?
I'll finish just before Mr. Singhvi starts.
All right, fine. ಆಯ್ತು ನೀವೆಲ್ಲ ಮುಗಿಸ್ಬಿಡಿ.
Let them finish, then I'll take another date,
You only with regard to fairness.
please. Just a few things, my lords. I'll only assist, as they said.
No problem. Yes. We will not resist.
Good.
Yes. ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಇದೆ ಅದಕ್ಕೆ ಕೂತಿದೆ. Yes. Thank you. ಏನಿಲ್ಲ ಅದು ಯಾರ್ಯಾರು ಬರ್ದಿರೋ ಮಾಡಿ. That will cut. That you need not mention, sir. I will. Yes. Madam ಬರ್ಕೊಳ್ಳಿ. Monday. 2:30 ರಿಪೀಟ್ ಮಾಡ್ಬಿಡಿ. ಬರ್ಕೊಂಬಿಡಿ. I'll call out the cases, right? Pronouncement ಇದೆ. Thursday 24 now. ಅದು pronouncement ಕೊಟ್ಟು. Pronouncement ಕರ್.
Number 3, pronouncement of order. Till number 1,
ಪ್ರಕಾಶ್ ಇರಲ್ಲ ಇದಾರ? Allowed post 306 English.
till number 2,
Dismissed.
till number 3,
Dismissed.
number 4,
Allowed quashed. It is made clear the observations made in the course of the order is only for the purpose of consideration in the case of the petitioner under 48 of the CRPC. Same shall not bind, influence the investigation proceedings against the other accused. Yes. ನಾಲ್ಕು ಕೊಟ್ಟು ಕಳಿಸ್ಬಿಡಿ. ಕಾಲ್ಔಟ್ ಮಾಡಿ ವಾಪಸ್ ಕಳಿಸ್ಬಿಡಿ.
list number 2, being spoken to till number 1,
ಏನ್ ನಟರಾಜ್ ಇದು? ಓ ನಾನೇ ಹಾಕಿರೋದು, ನಾಳೆ ಮಾಡ್ತೀನಿ. ಎಸ್ ಅದು ಇದು ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಹಾಕಿ. ಟ್ಯೂಸ್ಡೇ
till number 2,
ವಿಘ್ನೇಶ್ ಅದು ಆಗುತ್ತೆ. ಇಲ್ಲೇ ಇದೆಲ್ಲ ಹಾಕ್ತಾ ಇರಿ ಮೇಡಮ್. ಅವತ್ತು
and Suresh. Being spoken.
ಲಿಸ್ಟ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ. ಎಸ್ ನೆಕ್ಸ್ಟ್
Fresh matters till number 3,
Split up 21st. Custody ಇಲ್ಲ? Yes, 21st. Stay ಮಾಡಿದೀನಾ? List on 21st, further proceedings where the petitioner shall remain state till the next date of hearing.
Number 4.
Not present even today? But not the right time to listen to 10 husbands. Yes, yes. I have passed a detailed order. What has happened to the case? Like these proceedings. Yes. All right. You can expect something. Yes. List on Tuesday, fresh matters list. Yes. Next.
Number 5.
Ajay Prabhu. Interim, madam, interim, ನಾನು ಎಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಇದ್ರೆ ಅದು ಕಂಟಿನ್ಯೂ ಮಾಡೋದು. Yes. Next.
Number 5.
Ajay. ಇಲ್ವಾ? ಏನು? What's the matter? Jagdish?
MMDR.
What act? MMDR. MMRD, sorry.
The GPS location speaks something too different, my lord. He claims that he has a license, and the GPS location provided in the license is different than the GPS which we have
Then
found. That's
10ಕ್ಕೆ ಹಾಕೋಣ. ಈಗೇನ್ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ? ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಹಾಕಿದ್ಯಾ? ಯಾವತ್ತು? List on 9th in the fresh matters list. Yes.
Till number
Next.
6.
Yes, Mahesh.
they have married, they have produced their own instinct. If you look at this,
Huh?
if you see that marriage invitation, my lord, it looks like a child marriage. 17 years, 5 months they got married. Their own documents, they have produced the invitation, marriage invitation.
I think in settlement.
ಮದ್ವೆ ಆಗಿದಾರ ಅವ್ರು.
ಬೇರೆ offenses 3 kidnapping ಹೆಂಗಾಗುತ್ತೆ?
ಇಲ್ಲ, minor. When she was 16, she was taken away from, not even 16, when she was 14, she was taken away. Subsequently, they got married.
9 ಗೆ ಹಾಕೋಣ. List on 9. Next.
7.
Fake bank guarantee. Various fake bank guarantees have been generated.
Might I only request one document which will clarify this? They state that they verified this after the works is completed. Your lordship, prior to the work starting, the very same bank guarantee, they verified only
Records.
then the works of
I
contract.
have
is
records, but ಇವತ್ತು ಎಲ್ಲ ಫೈಲ್ಸ್ ಎಲ್ಲ ಎಂಟ್ರಿನೇ ಸಿಗ್ಲಿಲ್ಲ ನಮ್ಗೆ ಹೊರಗಡೆ.
signed. Document would be sufficient to
Use-
prove that the bank itself. Please, your lordship.
Ah.
That document would be sufficient to show that the CEO has verified with the bank and that the bank has certified that this bank guarantee is correct. And only then we have signed the works contract. Your lordship, this was during
Okay.
the,
We'll take it on Tuesday.
please, your
Yes.
lordship, please.
Records ತಗೊಂಬನ್ನಿ.
ರೆಕಾರ್ಡ್ಸ್ ಇದೆ ಮ್ಯಾಮ್.
Tuesday in the fresh matters list.
In fact,
Next.
there is the writ petition that was pending. There's an interim order also in our favor, your lordship, as against the contractor being blacklisted.
ಕೊಡೋಣ.
Please.
We'll see. Yes. Next.
Number 8.
490 ATM allowed. Charge was framed on 15/7/2020.
was posted today.
Charge frame ಆಗೋದು.
ಇಲ್ಲ, charge ಇಲ್ಲ, charge frame ಇದೆ.
Framed on
For the
15/7/2020.
husband.
Against the mother and sister, my lord. They have been made as, arrayed as,
Order sheet, yes, produced the order sheet, my lord. It's 15/7/2023.
Charge frame ಆಗಿರೋದು.
Charge frame.
ಆಗಿದ್ರೆ.
charge ಆಗಿದೆ, but there are no allegations against the mother, sister. And also the guidelines, Lalita Kumari, Arnesh Kumar, nothing has been.
ಲಲಿತಾ ಕುಮಾರಿ.
Lalita Kumari, Arnesh Kumar, and also the coordinate bench of this court has also passed a similar order. Where the charges against the sister, brother-in-law has been quashed, my lord.
ನೋಡೋಣ ಇವತ್ತು ಟೈಮ್ ಇಲ್ಲ.
Okay.
We'll take it on Wednesday. Fresh matters. Next.
Nine.
Appearing for the.
So they appear for the respondent. There is one
Lord,
objection that has been
all
raised in
five
relation to a
matters, we are
statement.
appearing on all five matters. It is offense under 138 of negotiable act. My lord, in the previous hearing, they had filed the.
I appear for the respondent. My lord. There is an objection in relation to a statement of objections, an office objection.
My
I
lord,
have received the
filed
affidavit to
along
comply
the
with the same.
compilation of all the documents in all the five cases. My lord, in this matter, my lord, the commercial court had granted a stay in the production of checks, my lord. Despite
Objections ಹಾಕಿದ್ದೀರಾ?
I have filed my objections in the matter, my lord. There is an office objection that has been raised. I have to file my affidavit in support of the same. I will
Lord,
file
that
it,
is
my lord, if I
comply-
may request
Comply
a
it
short.
by next
have
date.
requested
Next
that-
date ಯಾವತ್ತು?
10-9, my lord, before the trial court.
List on Tuesday. Fresh matters list. Next.
my lord,
Lord,
the
if-
stay may be granted, my lord.
Tuesday, yes. Next.
10.
5 ಗಂಟೆಗೆ
Obliged.
Lord, I am submitting the memo, it may be taken on record.
Keep it, give, file it in the registry, yes. Next.
So-
I appear to respond in this case, my lordships. My lordships, maintenance order has been stayed, my lordships. Interim order itself has not been paid, my lordships.
That is-
For the petitioner, Ajit,
My lords, it was heard on the last occasion, but I have produced documents to show that I've paid.
list on
lord,
Monday in the fresh matters list. Next.
Right. Very good.
Oh, sorry, Tuesday, yes. Idu Tuesday.
Grateful, grateful.
12.
11 also Tuesday, yes.
Much obliged.
12.
Respond number 2. my lord. Respond number 2. my lord.
Who's for the petitioner? Interim order there. List on 12th interim order subsisting shall continue to the next date of hearing. Yes, next.
13.
311 application.
12th in the fresh matter, sorry, 10th in the fresh matters list. Next.
14.
Post immediately after service of
I'll
notice
take
upon the
notice for them.
second. Huh?
I'll take notice for respondent 2 also.
Learned additional SPP accepts notice for the second respondent as well. Therefore, the service of notice is complete. List the matter on 19th. Interim order subsisting shall continue till the next date of hearing. Next. Fifteen,
Waiting for respondent number 2 complaint.
Sangmesh.
There was a direction issued by to cooperate with the
Where is
investigation.
it?
They are not,
Not
Not-
come? Lakshmi Angar, madam, is here. Not cooperated?
not cooperated. They have notices.
This
have been-
court on 26/7/2024 had passed the following order. A direction was issued to the petitioners to cooperate with the investigation by appearing before the investigating officer. And in the garb of investigation, it was also directed that no coercive steps would be taken against the petitioner. The learned additional SPP on instructions would submit that the petitioners have not cooperated with the investigation by appearing before the investigating officer. Therefore, the investigating officer, there is no representation on behalf of the petitioner. But 445 ಆದ್ಮೇಲೆ ಬೇಡ ಅದು. Yes, so and so. List the matter on 9, next ಇದಕ್ಕೆ madam, 9th. List the matter on 13th for further hearing. Yes, next.
16.
For the petition in this matter, my lord.
Waiting for respondent number 2 to file, Lord. Undertake to file wakalat.
Learned counsel so and so undertakes to enter appearance for respondents 2 to 4 registry to print the name of so and so as a respondent 2 to 4. Next.
My lord, there's a direction, the trial court should be deferred from framing of charges. and-
Whatever is there, yes.
Please,
The interim order subsisting shall continue till the next date of hearing. Next.
grateful.
Yes.
17.
We have for petitioner, my lord. Ultrasound machine.
Machine
Release ಮಾಡಿದ್ದಾರೆ.
ವರ್ಕ್ ಆಗ್ತಾ ಇಲ್ವಾ?
Stay ಇದೆ. Washing. My lord, this complaint has been filed on the sole ground that, there is no registration. That I have convinced my lord that, that I have filed an application on time. So there is
We'll
a
have
deemed
to-
registration, my lord.
ಬೇರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆಯಾ?
Your lordship has followed that other.
3002
3002.
reserved. Yes. Next.
Much.
8.
ಬಟ್ ಸ್ಕ್ಯಾನಿಂಗ್ ನಡೀತಾ ಇದೆ ಅಲ್ವಾ?
Have
Yes.
you for petition in this matter?
ಏನ್ ಮೇಡಮ್ ಇದು?
So 307, 506, 341, 509.
ಇಂಟರ್ಮಾಟ್ ಇದೆಯಾ?
Intermodal.
ಹಂಗಾರೆ
Petitioner-
ಕೊಡುವಂತ ಕೇಸೇ ಅಲ್ಲ.
No, your lordship, he is none of the assailants. While unknown 3 to 4% have been
ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ನೆಕ್ಸ್ಟ್.
90.
306, 120 being. Complaint is at page number 21.
ರೆಕಾರ್ಡ್ಸ್ ಕಮೆಂಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ charge sheet ಆಗಿದೆ.
ಅದೇ ರೆಕಾರ್ಡ್ಸ್ ಕೇಳಿದೆ. 306
ಎಲ್ಲ ಬಂದಿದೆ ಎಲ್ಲ ಅದನ್ನು.
ಆಯ್ತು. ಟ್ಯೂಸ್ಡೇ. ಎಸ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ನೆಕ್ಸ್ಟ್.
20.
For the petitioner, my lords, your lordship had directed them to secure the report, my lords, but apparently.
ಎಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಇಟ್ಕೊಂಡು ಇಲ್ಲ ಕೊಡಿ.
My lords, one submission, my lords. It seems that the charge sheet has been filed now, my lords. I got the information yesterday. I may be permitted to withdraw it and file.
ಇಂಟರ್ಮಾಟ್ ಇಲ್ಲಲ್ಲ?
There's no intermodal.
ಸರಿ. ಎಸ್ ಮೇಡಮ್ ಚೇಂಬರ್ ಕೇಳಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಒಂದು ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ.
I'll place a memo.
ಲಿಬರ್ಟಿ.
Yes,
ಎಸ್ ನೆಕ್ಸ್ಟ್.
21.
ಉದಯ್ ಪ್ರಕಾಶ್.
Promise to marry. 376 and 417.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ.
Charge sheet file ಆಗಿದೆ.
CC ನಂಬರ್ ಕೊಡಿ ಅವ್ರಿಗೆ. ಸೇಮ್ ಆರ್ಡರ್. ಎಸ್ ನೆಕ್ಸ್ಟ್.
22.
The petitioners, my lords. It's the allegations with respect to the assault and unlawful assembly.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಹೋಗುತ್ತೆ.
My lords.
ಹಾ.
The allegations with respect to the unlawful assembly and the assault, my lord, during the course of the.
Serial number?
22, my lords. During the spot inspection, my lords, the panchayat members.
ಕೇಳ್ಬಿಟ್ಟು 58 ಇದೆ ಅಷ್ಟೇ. ಒಂದು We'll have it on Tuesday.
Place, my lords.
We'll do it this way. All fresh matters we will have on Tuesday, which are listed up to page wise ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್.
22.
ಪೇಜ್ ವೈಸ್ ಕರೆದ್ಬಿಡಿ. ಇಂಟರ್ಮಾಟ್ ಅವ್ರಿಗೆ ಟ್ಯೂಸ್ಡೇ ವರೆಗೂ ಆಗದೆ ಇರೋ ಇಂಟರ್ಮಾಟ್ ಇದೆಯಾ?
My lords, my 22 serial number, interim order is not granted.
ಯಾ, ಒಂದು ನಿಮಿಷ. ಟ್ಯೂಸ್ಡೇವರೆಗೂ ಕಾಯ್ಬೋದಾ? ನೋ ಪ್ರಾಬ್ಲಮ್? ಎಸ್. All fresh matters on 3/9, whichever is listed today, records. Admission without interim order on 24/9. Interim order ಇರೋದು ಒಂದು 2 ವಾರ ಹಾಕಿರೋಣ, ಆಮೇಲೆ ನೋಡೋಣ. Settlements are all on 3/9/24. Interim orders wherever are there will continue. ಸ್ಟೇ ಮಾಡಿಲ್ವಾ? ಟ್ಯೂಸ್ಡೇ ವರ್ಗ ಆಗುತ್ತಾ? ಅಲ್ಲ, ಟ್ಯೂಸ್ಡೇ ವರ್ಗ ಆಗುತ್ತಾನೆ. ಹಾ, ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತೆ. ಮೇಡಮ್ ಅದ್ ನೋಡ್ಕೊಳ್ಳಿ ಯಾವ್ದು ಪ್ರೊಕ್ಲಮೇಶನ್. ಅಕಸ್ಮಾತ್ ಲಿಸ್ಟ್ ಆಗಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ you move it for 2:30 on any day, I'll take it.
Your lordship, I'm told that that matter was called. Your lordship, we were told by Mr. Raghavan's office that they submitted later to your lordship stating that Mr. Raghavan won't be available today.
I
And
don't know.
therefore third was, that is what they had informed us, your
No,
lordship.
because I saw your name in the earlier
Okay.
order.
Apologize, your
No,
lordship.
no
In
problem.
fact, the council came and told me that's why I returned.
No problem. I posted it on.
13th, they say now, right?
Yes.
Please, your lordship, apologies. We were told by Mr. Raghavan's office
That's all
that
right.
it's
No problem.
postponed
No,
to
it's
third.
not that. Your council and record should have been there. It's not you should be there.
All of us were.
Yes, yes, no
Okay.
problem.
One submission, my lord.
Lordships, kindly, my lord.
Madam? Given by, in this manner is what I told now. If there's anything very urgent, you tell.
Lordships, kindly, my lord, may I make one submission, my lord?
Dates will be given, yes. Huh? Extension of parole. ಅದು ಹೇಳಿ ಮೇಡಮ್, ಹೇಳಿ ಮೇಡಮ್. ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಪರೋಲ್ ಅಷ್ಟೇ. ಟ್ಯೂಸ್ಡೇ ಹಾಕ್ಬಿಡಿ.
Lordships, kindly, my lord.
ಇಂಟರಿಮ್ ಆರ್ಡರ್ಸ್ ಎಲ್ಲಿದೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Serial number 71, warrant has been issued, my lords.
Kindly
have this matter on Tuesday.
Tuesday, yes. Monday ಗಂತೂ ಆಗಲ್ಲ, Monday list close ಆಗ್ಬಿಟ್ಟಿರುತ್ತೆ, ಅದಕ್ಕೆ Tuesday.
71.
Serial number 73, my
ಎಲ್ಲ
lord.
Tuesday or Wednesday, madam, ಕೇಳ್ಬಿಟ್ಟು ಕೊಡಿ.
Serial number 35, my lord.
Serial number 73, my lord.
Where interim order is not there, my lord, maybe posted.
we are filing objections in the matter, your lordship.
my lord.
ಅಲ್ಲ, madam, interim order 25 ತುಂಬಾ ದೂರ ಆಗುತ್ತೆ. Wait, ಯಾವತ್ತು ಹಾಕೋದು? ಗಲಾಟೆ ಮಾಡ್ಬೇಡಿ. 10th, 11th distribute ಮಾಡಿ. Sir, 1 minute, wherever interim orders are not there, 10th and 11th it will be distributed. Yes.
10th or 11th.
With your lordship's kind leave, lordship, serial number 65.
2:30
Date may be
matters.
allotted, your lordship.
One ನಿಮಿಷ. Oh, this RP. Don't get touchy about it just now. Wait, argument. Am I passing an order now? Right? I'll hear you and pass orders. Wait. Don't think I'll get carried away by submissions. Yes. I have to, but sometimes, yes. We'll take it on 21st. Adu Saturday. Why? No utilization by RP. That I have told you.
That's one submission.
In custody.
On 21st.
It's the accused.
ಗೊತ್ತು. ಬಿಟ್ಟು ಸಿಂಗಲ್ ಇವರೆಲ್ಲ ಕೇಳ್ತಾರೆ. ಗೌತಮ್ ದೇವ್ಲ
Serial number in custody.
ಯಾವುದಕ್ಕೆ? ಸೆಟಲ್ಮೆಂಟ್ ಡೇಟ್ ಯಾವತ್ತು ಕೊಟ್ಟಿದೆ, ಯಾವತ್ತು ಬರಲಿ? ಸೆಟಲ್ಮೆಂಟ್ ಟ್ಯೂಸ್ಡೇ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್.
Appearing for respondent number 2, my lord.
Assign dates.
In the
Dates will be
appeal number
given, yes.
34.
My lord, 78, Swami.
Will be effective.